to film events or even record events, although I will seek to ensure that that doesn't disadvantage anyone or indeed prevent anyone from taking full part in the event. I've got an opening that I'll go through this morning that will last maybe 25 minutes, half an hour. I'm very happy to take questions at the end of it. I will have some questions for parties and for people who are here today, in part because we all know it happened. Christmas got in the way of prep for quite a lot of this inquiry, and there has been some sort of cross-purpose communication going on with my office and with the office with the party. So I need to make sure I'm fully up to date on everything that we've got. And I also want to establish for everyone today a programme for the next, we'll call it a couple of weeks for now. We'll see where we get to, just so everyone understands when we're likely to hear from the various witnesses and where there will be an opportunity for interested parties, others than those who are sitting around the main table, to be involved if they wish to do so. Let me start by just seeing who I've got from the main parties. Let me start with the appellants.
Good morning, sir. Not good start, we are. Good morning. My name's Charlie Banner, KC, and I am co-counsel with Mr. Nick Grant of council, who sits to my right. And the witness team that I'll be calling, from whom you have various documents. I might just ask them to raise their hands if they're here. So it's Jeremy Smith, in relation to landscape and visual, Miss Gail Stoughton in relation to heritage, Mr. Asher Ross, who have two appearances, there's 5-year housing and supply and then in planning, and Mr. Alan Brackley in relation to drainage, who'll be probably at the conditions session, subject to discussion at the time table in due course. And Richard Burton, Mr. Richard Burton, who will deal with design matters. Here we are, Mr. Burton. And that is our witness team, the various other people. And James Bevis.
Mr. Bevis, thank you.
Of course, Mr. Bevis and Transport, but we're not calling him as such, but he's going to be made available for questions. So that's our witness team, the various other people here on behalf of the appellant. But I won't introduce them all because it'll take quite a bit of time.
Thank you, Mr. Banner. For the council.
And good morning, sir. I got a list of appearances, so when I have my opening round, I'll hand that in as well. But it's short in the sense that my name is Heather Sargent, Sargent of Council. I appear on behalf of the council, and I will be calling Dr. David Hickey, who is sitting immediately to my right on landscape and on heritage matters, and then to his right, you have Mr. Tim Dawes, who is my witness on planning matters and will also be participating in the housing land supply session.
Thank you very much. Lists are very helpful to me of witnesses, not least so that I don't have to decipher qualifications to translate them into the decision. So that would be useful. Thank you. Okay, I've got a number of people here sitting in the seats. I had indication that a Mr. Khan wanted to address inquiry. Mr. Khan here. Mr. Khan, very good to see you. Anyone else wish to make a statement to the inquiry? I'll explain perhaps the opportunities that you have. I have received all of the comments that were made to the council during the application process. Also, when the appeal was notified, I received comments that came to the planning inspectorate. But there is an opportunity if people wish to make statements to the inquiry to do so. Mr. Khan, as I say, did indicate that he wished to do so, and I'll have a little chat with you in a second about the best time to do that. But very typically, if I make the bold assumption that you're here because you don't agree with the principle of the development, your comments could be taken at the end of council evidence, but in this case, we're probably going to run on what's called a topic basis, which means we'll deal with both parties' evidence during the day, during specific sessions. But quite often I give an opportunity for people to make statements this morning because you're here and you have an opportunity to do that. So on that basis, is there anyone else other than Mr. Khan who wanted to make a statement to the inquiry? I have 4 hands go up. Let me just quickly grab your name and see if I can relate it to documents I've already had. And I will go from my right to left. So if I start, sir, with you. Thank you. Yes, one of the 8 responses I received was from the parish council, from Miss Thomas, I think. I think I had it's your clerk. Thank you very much.
From the parish council. Councillor Chris Kennedy, one of the 3 ward councillors for Bramley Ward. Here, the other 2 to introduce themselves. We would like to speak to you. We have a particular order we'd like to follow, if that's so. If I'll let the others introduce.
Okay, let's keep going down the road.
Councillor Tony Durham, Parish Council Chairman for Bramley.
Thank you very much. So, sorry, you're a Basingstoke and Dean councillor, but also parish council. Thank you very much.
It's Councillor Nick Robinson, Ward Councillor for Bramley and Chair of Development Control of Basingstoke.
Okay, I'm very happy to hear from you. I obviously don't need people to repeat things. I mean, we've got a couple of you from the parish council and we've got 3 representatives from the ward councils. We obviously don't have to have repetition, but I'm sure you've spoken to each other about how you're going to come and present to us. So that's very helpful. Does it work for, I'm asking a question to 6 people here, but let's try it. Does it work for the 6 of you that you want to speak this morning, or do you want to stay with the inquiry, listen to the evidence, have opportunity to question the witnesses yourself, or your preference is a statement first thing? That's fine. Your intention is you have written statements or you've got prepared statements that you wish to make. Mr. Carden, I've got a team in front of you who are nodding in unison, but I'm just checking the same questions by you. That's fine by you. Thank you. Let me put it this way then. I think the best way to do it, and the way that I've typically done it in the past, is that I'll ask the main parties to give their opening statements if they so wish. And then we'll open the floor to you, and I'll take you in turn, whichever order that you feel works best for you. Probably better that we bring you up into the corralled off pen at the front. Because it just means you can engage better with me and with the main parties. That, as an estimate, will be around 11:15, 11:30 would be my guess. Does that work okay for everyone? Have I captured everyone who wished to address the inquiry then? Good. Thank you very much indeed. I'll come back to you when your turn is due. I note that on my desk was a set of attendance sheets. It's worth saying it may be that the council wish to retain attendance sheets these days, but planning inspectorate don't need to take them. There's lots of reasons. One is personal, just managing it, but also GPDR implications have started to raise their heads in some of the events. They give very little benefit as long as I take good notes and I get good listings from you. But the council, I know for various reasons, sometimes wish to retain them. So I'll leave it at that. There's no necessity for me to track them down. Thank you very much. I've had notification letters. I think I've got one that was updated here because I had an 11th of November. Oh, I've got a 9th of December one as well. And I've obviously had the response. So many thanks for providing those. Let me just check that the appellants team is aware. I've referred to these 8 responses. I've had them come through to the appellants. Thank you very much. Site notice is done. I've received and read proofs of evidence on behalf of the witnesses that were listed by the advocates a little earlier. Other than that, in relation to housing land supply, I think the fault probably lies with us because I think they were provided on time, but they haven't come through to me until I was driving yesterday. I wasn't checking my phone as I was driving yesterday. I checked it when I quickly add that. I'm hoping there might be some hard copies for me, though, of those so that I can work with them over the next few days. I don't anticipate we'll be into the depths of housing land supply. I undertook at the pre-inquiry conference to make sure that was later in the process, because I knew it was always going to be a tight timescale on that one. But if I've got hard copies, those can be handed in at some stage. I'd be very grateful. Let's just deal with statements of common ground, because I think there's an issue with that as well. I had statements of common ground on landscape and one on drainage that was very long, but its meat was less so. But I didn't have, until I think as I was driving up today, a one on the scheme in general. I assume that there is one now.
Yes.
But again, a hard copy would be useful if one's.
We can get that to you. I know there's a transport one as well.
Did I not mention the transport one? Sorry.
If you did, I.
No, my fault. Now that'd be very helpful, because I'm assuming there's agreed sets of plans in that. There aren't many plans here. We have a site plan and we have this updated access plan, which I agreed to just after the conference as being okay to accept. I think the council had taken that on board. I'm assuming that's it in terms of plans. There's some illustratives. And indeed, I think we need to just establish which illustrative people are referring to in the plans. But outside of that, I think they're captured in the statement of common ground. Ms. Sargent, you were...
That's correct. So when you receive the statement of common ground, there are only two plans for the agreed basis, which is the location plan and the access arrangement.
Excellent. That's very helpful indeed. So a hard copy of that would be very useful for me so that I can catch up with where we're at on it. Right. Might be interested in how long this will go on. It was originally programmed for 11 days. At the pre-inquiry conference, I was fairly bullish about suggesting that it didn't feel 11 days. I've looked at the program. Now, I set up an initial program and then I received the timings late yesterday. So I rapidly updated it. You may have received two versions of that. I don't know from the case officer. I'm hoping you've received a later one. But also I hadn't received the reference from the council. They're interested in taking heritage first. Ignore, if you like, the order. Let's work on timings and let's work on order. Let's have a little bit of an open house on this, because I think getting this programme right is going to be very useful for everyone going forward. So let me just check. Did people receive my draft?
We received a draft. It sounds like we received the earlier one. We've actually had a go at tweaking it to see if we could come up with something that we think will work in terms of time. So we've actually got our own updated, but it sounds like you've updated.
Very good. It was there as a prompt. Let's deal perhaps with the first thing first. Order. The order that I'd set at the pre-inquiry conference was landscape, heritage, etc., etc., etc. Council came back with a request to go heritage, landscape.
No. So that's that. Sorry, my microphone doesn't.
I wonder if mine kills everyone's microphone.
I think it does. That's absolutely not our request. We don't agree with that suggestion, which has come from the appellant.
Okay.
But I'll come back to that in a moment, I'm sure.
Sorry, I should just emphasize, this is something of the cross-copying of emails that I had yesterday morning and while I was travelling. Two case officers have picked it up in bins, and that's what's happened. Right, let me just put it out there then. Mr. Banner, you've got a programme that you've worked on.
Yes.
Have you shared that with the council? How are you in terms of...
Right. No, we were going to talk through it now, but
okay.
You can say we're in your hands, because if you've updated the programme, it probably makes sense to look at the version, or we can show you what we think we think will work.
Right. I took the timings, and I'm hoping that the timings I've got are now the timings that the parties had given.
Yeah.
And on that basis, I had got us to a finish by Friday the 20th. Does your programme, Mr. Banner, achieve that?
It does in a different way. Yes, it does.
Okay.
We think, yes, well, probably easier to show you what.
Okay.
No, I can't, because...
I have the power. And
Thank you. Yes, so on our version, we still finish by Friday the 20th. We think that the earlier parts of the inquiry, so landscape, heritage, design, are likely to take a bit longer, but that the later parts of the inquiry will likely take a bit less time. So I think it may be easier if I could talk you through what we've prepared, sir.
I think you've got the power.
I have. Oh, sorry, it's the shared power.
I'm just a little worried that Ms Sargent is not in the loop in terms of what's proposed. But how many copies have you got?
Got lots of copies.
Let's have a couple of copies shared around. I can then have a quick look, see how it relates to mine, and then we can perhaps get some resolution on it. I mean, if we've got the principles, I'm happy this can be resolved in breaks, really, but I want the principles. It looks very like mine.
Could I possibly just talk you through, sir? Our own view was that it would be sensible to hear heritage first, because Dr. Hickey's landscape evidence expressly draws upon his heritage evidence, so we think it's antecedent here. But we understand the council is not prepared to deal with heritage today, and so at the moment we've kept landscape in first. We think that landscape is like, given the time estimates, which didn't quite match up with the first version, so it sounds like I think that's the first version of your timetable. We think landscape is likely to spill over until tomorrow morning. As you'll see then, we think then we could get to the end of Mr. Smith's evidence tomorrow. Thursday then would be effectively the design matters in the morning. It may be actually that it takes less than the whole of the morning of the Thursday. We can start heritage earlier, but at an abundance of caution, we've assumed that we start Dr. Hickey's heritage evidence in the afternoon of Thursday. I will be 3.5 hours with Dr. Hickey and heritage, and that will then take us through till mid-morning Friday. That would then mean Miss Stoughton taking us till sometime around lunchtime on Friday. We've then an issue because it clearly wouldn't be appropriate for Ms Stone to be halfway through cross-examination over a long weekend for all sorts of reasons. So it may be then that we have an early finish on Friday, maybe obviously subject to, I think then on the Tuesday the following week would be finishing off Ms Stone and the housing supply round table, plus the infrastructure and transport matters, the sort of, they call it the miscellaneous matters. We could then probably start Mr Dawes in chief on Tuesday. And then Wednesday would be the remainder of planning. Thursday, we have scheduled in the morning conditions and planning obligations. We suggest, unless you have you consider them contrary, so that the drainage discussion would be best suited to the condition session, given that parties have agreed that it bears upon conditions and the precise formulation of the condition. And that's why there's a bit of time saving from the previous week, as the previously drainage was scheduled for the first Friday this week. We do feel that a little bit more time for preparation of closing submissions would be needed than what was proposed previously. So what we had in mind, again, subject of course to your views, so in the council, would be effectively the second, third and fourth segments of Thursday, with a late start of around 12:30 on Friday. And then that would mean if we started at 12:30 and we were each an hour, we'd still be off by 2:30, 3-ish, and we'd have a sandwich beforehand and an early lunch beforehand. So we still have an early finish on the Friday. That's what we think, having matched that up. We spent quite a bit of time matching that up to both parties' time estimates. We think that's what we might call a resilient timetable. But to say maybe that's quite similar to the updated version you circulated that we haven't seen.
Mr. Banner, it is very similar. It just overlaps Ms Stoughton into that,
yes,
into next week slightly, but there was plenty of space in next week to accept that. Sergeant, I appreciate you've only recently seen this, but you had some idea of when I think you wasn't it earlier. What's your instant views, and then we'll perhaps sort of work out how we finalise this after.
Generally, I mean, you heard what we said about the order. So the difficulty the council had with that was that the request to switch it around was only made at lunchtime yesterday. So I'm afraid it's impossible for us to accommodate that realistically. I'm not proposing to call Mr Dawes on design. This is an outline application for planning permission, and sorry, to give evidence in chief on design. So we can discuss that further, but that wasn't my intention. I was going to call him once to give his planning evidence at the end. So I don't think design is going to occupy all of Thursday morning because, again, given that this is an outline application, I don't think I'm going to be very long with Mr. Burton. I certainly won't be longer than the hour that I estimated. I think I'll be shorter. My only query was that the version of the timetable that I received from via your case officer, sir, had a blank on the Thursday afternoon, and maybe that was just an oversight, but I just wanted to check that there wasn't some difficulty with that last session on the Thursday.
No issue with that last session on Thursday. I just thought that in my original plan, Ms. Stokes' cross-examination would have crossed over into that. I'm sort of with you. I was quite surprised to see Mr. Dawes' name come up in the original landscape and design sessions.
Sorry. I'm going to get the habit eventually, sir. So the reason we put that is we'd understood that section 4A of Mr. Dawes' proof was making points about urban design and character that went beyond. Section B deals with landscape, and that seems to be a summary of Dr. Hickey's landscape evidence in a way that you would expect from a planner. Section C seems to be a summary of the list of buildings evidence of Dr. Hickey, and section D seems to be a summary of conservation area evidence. So that's all saying I'm drawing together the strands of something else, and that's all fine. Section A we had understood to be a freestanding piece of analysis from Mr. Dawes in relation to urban design and character, consistent with our understanding of the statement of case. And of course, there was always going to be a session on quote unquote design, not in terms of architecture, because of course it's an outline application, but in terms of consistency, settling pattern, and that sort of stuff. And we'd understood that the witness the council was holding out in relation to that was Mr. Dawes. If the council isn't offering any evidence in that, that's fine. We'd like to know, but clearly, if the council is taking a point on settlement pattern, etc., we'd like to know who we should ask questions to if it's not going to be Mr. Dawes.
I mean, the evidences are set out in Mr. Dawes' proof, and if Mr. Banner wants to ask him questions about it separately this week, then we can accommodate that. But I don't think it's an efficient or necessary use of inquiry time for me to have a separate session on evidence in chief just on that point.
Well, there's a fairness point, sir, because of course we have the right, as a matter of procedural fairness and actually a matter of legislation, we have the right to the last word on each issue. And Mr. Burton deals with that issue. We're doing this inquiry on a topic. Sorry, I'm so sorry. I'm pressing button. Mr. Burton deals with that issue on a topic, or that particular topic, and we are dealing with this inquiry on a topic basis. So if the consequence of the council's choice for Mr. Dawes to give the evidence on this is that he has to give evidence twice, that is the consequence of their choice, just as it is that both parties, having chosen to call one witness who has an supply, are going to have to call each of their planning witnesses twice anyway. That's just the way of the world in a topic-based inquiry. And effectively, it would be a cross-examination, as I understand it, on section 4A of his proof. But it can't be left to the end because otherwise I have to recall Mr. Burton.
Sergeant, what I'm going to do is give you a chance to perhaps have a chat with Mr. Dawes in the break, but come back to me because I can see the argument. If Dr. Hickey hasn't dealt with the issue of design phrased in the terms of the relationship to the settlement, does it meet the existing settlement pattern? Because Dr. Hickey's evidence goes to landscape very specifically, then to call Mr. Dawes to give evidence on that as part of the planning evidence doesn't allow the appellants to come back with Mr. Ross in response, in fact. Now, there may be a simpler and easier answer to that, but rather than just do it on the hoof now, let there be a little discussion and seek resolution on the right way that best suits the delivery of your case.
So yes, I think there is a mismatch between the two sides' evidence in that Mr. Burton's evidence does seem more squarely, he is a design witness. whereas Mr. Dawes, I know, is not putting himself forward as a design witness independently of being a planning witness. Now, there may be some overlap, which means that there isn't a direct correlation between Mr. Burton, everything that Mr. Burton is saying, and the section of Mr. Dawes' evidence that my learned friend's referring to. But I'll talk to Mr. Dawes about it, so and see where we get to.
So I probably should just say as well for the body that we've got absolutely no problem with Miss Stone's cross-examination being on Friday as long as we finish it. So if things do go shorter, obviously we're completely supportive of wrapping her up if we can. It's just the only problem is if she ends up halfway through.
The only slight change that I would suggest is that I would seek to get things done on Friday. I appreciate I'm going to give advocates as much time as I can, but I think with site visits and conditions and planning obligations Thursday, and that's even if things don't go well, they're going to end up there.
Yes.
I'd like to get things wrapped up as early as possible on Friday for lots of reasons, but I don't see any reason. Right. We will review this during the inquiry, but at present, I see no reason that we're going into the third week.
Yes.
That was originally programmed, and I'm sure that probably sits with the council comfortably.
I completely agree, sir.
That's helpful to know. Ladies and gents, that was quite a long chat as an attempt to try to pull together a programme so that witnesses know when they're likely to be addressing the inquiry. I know what I'm trying to achieve in terms of wrapping things up on time, but making sure that we've met all of the needs of the inquiry too. The outcome being, while there's perhaps a bit of fine tuning to do between the appellant's programme, which was developed from one of my first programmes, which was quite similar to my second programme, which I think the council got, it should all be completed within 2 weeks. So we're aiming to be completed by Friday the 20th. The fine detail on that, let's reserve until there's been an opportunity for some discussion, either within the teams or even across teams, just to make sure that we can resolve the situation with Mr. Dawes. But I think with a fair wind, we're looking like we've got an inquiry that works well within 2 weeks, in fact, works comfortably within 2 weeks. And yeah, I just might be a bit pushy, Mr. Banner, to try to get you to start at 9:30 or 10 on Friday the 20th, rather than have the morning me relaxing in Basingstoke. Good, that's helpful. We'll come back to it, but that at least gives us a starter for 10, as it were. Thank you very much indeed. Okay, just so people know how inquiries tend to run, those of you who haven't had the joy of being with us in one of these before, we did start at 10 today. My intention is to start at 9:30 on the morning. I've seen there's no problem with that from anybody's view. No one got long distances to travel each morning. Typically, we'll break at lunch around 1. We'll have short breaks morning and afternoon, and we'll look to finish at around 5. Let me just check with the council whether there's any restrictions on the use of this room over the weeks.
Not the 2 weeks, no.
Not the 2 weeks, so we can leave papers and the room set up as it is.
The room will be locked. It's locked every evening.
Fantastic. That's very helpful indeed. Makes change from occasionally having to give way for the Zumba class to the inquiry. Thank you very much. Time is flexible, subject to the needs of the inquiry, and advocates, I hope, will assist in finding convenient breaks during proceedings. I have driven through Bramley. Let me put it like that. I've driven through Bramley so that I can understand the relationship between the, if you like, the train station through to this church and the conservation area extent of. But I haven't done the full site visit that I will need to do as part of this inquiry. We've made a suggestion on the programme that the site visit is very likely to happen around Thursday the 19th, which seems to make a lot of sense to me. It also makes sense in these sorts of circumstances where we've got quite extensive public footpath networks, a number of heritage assets from which we're expecting to understand the views to and views from, that an itinerary put together by the teams would be kind of very helpful to make that site visit well focused. I'm not sure who's ideally best to lead on that one, other than the council often had the contacts with the parishes to work things through. How are we doing?
Yes, so just to say that we have begun in discussion with the appellant. We have a draft itinerary, and obviously we can share that with the parish council and board councillors if they wish to add any additional points
That's very helpful, because that was going to be my suggestion, if we had something to start with, just to make sure we capture all of the local interest in terms of relevant views that might need to be taken in and around the site. We've got till Thursday, but if there can be progress going on that, that would be really helpful. Thank you very much indeed. Just remind parties that when we do carry out a site visit, there will be no discussion on the merits or otherwise of the case, and we will be flexible on the timings, just really to suit the inquiry. Yes, I mean, it feels like that Thursday afternoon, early, so perhaps late morning, early afternoon will be a very good slot for that session. I'll set out the main issues in a moment, but then we'll invite the main parties to make their opening submissions. And as I suggested to those in the audience here, I'll then give an opportunity for you to make your statements to the inquiry, following which our programme has set out topics, that is landscape, design, heritage, as the main topics, for which there'll be witnesses from each of the main parties. Those witnesses will present their evidence, and chief will be subject to cross-examination, will be open to questions from myself, or indeed re-examination from their own team. But we also have a couple of round table sessions that will take place at the present timetable next week. The principal amongst those will be the housing land supply one in terms of time. But let me just check, we're still programmed for one on infrastructure. And I wonder if that's still required in terms of the council's position on infrastructure, or in that we'll have a 106 discussion on whether that's met and delivered against what was your reason for refusal 5, I think, in the putative reasons for refusal. So I just wanted to check very quickly on that as a round table.
No, so you're correct in that it really is a question of whether the wording of the section 106 is satisfactory. We don't suggest there's a need for a roundtable from our perspective beyond the discussion on the section 106.
Okay, that's very helpful. I assume there's still discussions going on that draft between the parties. I only had a very short window to have a quick look at it, and I put back some comments about signatories, which is obviously usually an easy one to check. I'm sure there's a simple answer to that. Over the week, I'll be looking in a bit more detail. Any cases said, I'll flag it up as we.
So just to give you a heads up, we anticipate the final version. The final version, subject obviously to any further comments you have, will be ready sometime on Wednesday, or an updated version, subject to any comments you have, will be ready on Wednesday, so tomorrow. I can't absolutely promise that as a cast iron promise, but that's our anticipation.
We'll have the entertaining discussion about when a signed version will be able to be submitted at a later date. Okay, thank you very much. Following the submission of all evidence, I will allow the main parties to make statements if they so wish. The council present first, followed by the appellants. It's always helpful to me to have written copies of closing submissions, and hopefully we'll be able to put a suitable gap in the timetable of the inquiry to give you an opportunity to prepare and deliver that. Thank you. I've been provided with a list of draft conditions, which I actually had before the statement of common ground, but I guess they might be associated with the statement of common ground as well. Are they agreed between the parties? It wasn't clear, but I'm
they're agreed, save for the drainage condition, where it's agreed there should be a condition, but the wording of which, for reasons you're aware, is not agreed.
Okay. All right, thank you. That's very helpful. I'll work my way through those. If we get any other conditions that raise their head during the course of the inquiry, we'll add those on, and we'll discuss them at a roundtable session on the Thursday, probably next week, where we'll also consider the 106 undertaking. I did put out a note. I'm hoping this came through from the case, that I seek a SIL compliance statement to go with the 106. Just very quickly, where are we at on that?
I may have misread an email very rapidly yesterday, but I think it's available to Pins and was resent to you from the appellant. But yeah, I can see nods from the other side of the room.
It's entirely possible in the slight issue of case officers crossing over Good. If I have it, that's excellent. Thank you very much. Touch very briefly on the matter of cost, because I've had no indication of applications for cost at this stage. However, were one to be made, I would expect that there would be a clear and early indication. While I have no intention of doing so at present, I do also have the power to initiate costs, as people know. Now, just in terms of completion of the inquiry, which we're hoping will be next week, only except with any other material be accepted post that. Just in terms of main issues, I'll set them out and I'll see if there's any questions from anyone either in the audience or around the table before coming to parties for openings. The main issues have been trialled previously in the pre-inquiry conference note, and I'm assuming, because it was still slightly in question at the time of the discussion, that the putative reasons for refusal the council set out, 4 and 5 regarding pedestrian safety and store servicing, are no longer issues for the council.
That's correct. So you will have written confirmation in my opening in a few moments.
Perfect. Nor condition 7 regarding infrastructure, and we've touched on that already. However, I do know that matters of transport, access, infrastructure within the village remain particular concerns for local residents, and haven't dropped from the issues from that point of view. And I'm sure in the statements that we are due to hear, they'll be expanded upon in terms of what I've read in previous submissions. But even so, well, there may be other matters I'll list here. Evidence on the list at present now reads whether the proposal complies with the development plan, and if not, whether there are material considerations justify a departure from it, including the extent of the housing land supply shortfall. The effect of the proposal on landscape character and appearance of the area, including the settlement pattern, the effect on heritage assets, and whether the proposal makes adequate provision for foul drainage and other infrastructure requirements that retained, and the effect on transport capacity and highway safety retained, albeit I accept the council's position. That's what that stands. Does anyone want to add to those issues? They haven't developed much from our pre-inquiry conference. Thank you. Let me just check that we've got, perhaps I'll put that on, what have we got on the table here?
They're the core.
Is that all of the core documents? Is it the proofs? Right, it's the core documents. Okay. Do we have copies of the proofs elsewhere? Right. If people in the audience hear reference to documents or wish to check on things that are raised during the submission of evidence in the proofs of evidence, there are hard copies available in the room. I'll say in the room because some are here and some are down here. They're obviously not easy for you to access from where you're at, but in the breaks, if you want to look and check on anything, please feel free to do so. All I'll ask is you don't take them away from the room because they're there as a resource for everyone, but also occasionally for witnesses when we just need to capture the hard copy to read from. Any other late documents? Let me just check. I've referenced, obviously, the statement of common ground. I've referenced the housing land supply proofs, but anything else?
To check, you've got there's a couple of documents that Mr. Hickey's landscape proof references doesn't provide the inquiry with, and we think it would be helpful to have them. There's a British standard, number which escapes me, but which I have in my documents. And that is something which you ought to have, and I think has been BS 7913 2013 Guide to the Conservation of Historic Buildings. That's been added to the core documents. I don't know whether you've got a hard copy, but obviously we can provide you with one before Dr. Hickey's heritage evidence is heard. Similarly, he refers in his heritage tables to something called ICAMOS.
Yes.
And again, we think, given the extensive reference, that would be helpful for you to have that. I've got a hard copy of that here now. I've got my hard copy, then Mr. Grant can provide you another hard copy. And lastly, he refers to the Glivia 1 working party, and we provided an extract from Olivia 1 showing a list of names on that working party. So if we could just hand that up. I think, and again, there should have been there's probably some hard copies sitting outside Key House in Bristol, I suspect. But not much use to in Basingstoke. So I think that's all. Somebody will correct me if I've missed something. So that's all from us. Sorry.
You very helpfully have handed me up two of them, not the British standard.
Yes, we'll need.
I'm fine if that's coming in later.
Yeah, we'll get that to you later.
I'll just go to Mr. Sargent to see if there's anything from the council, and then we'll pin down some document referencing just to assist everyone going forward.
The only things are a couple of documents that I will be referring to in my opening submission. There are two case law authorities that I put you'll see the citation will be in the opening in response to the appellant's reliance on Newcastle, which is a recent judgment from November. I appreciate, sir, you will. I think both my learned friends will be familiar with both of the authorities and probably read them several times before, but you might not have had that pleasure, sir. So I will provide, as soon as I can, the paragraph reference and the propositions that I take from those, so that you have those.
Thank you.
The other thing I referred to in opening is the Clappers Lane appeal decision, which I know the appellant is familiar with. It goes to the stage. And the debate around the wording of the condition for that. So I know the appellant.
It's in the core document.
Is it already in the CVs? I couldn't find it yesterday. But if that's already there, thank you.
Yes, 4.9. Thought I had it. Okay. Okay. If it assists just for us going forward, I'm keeping a running list of documents then. I'm a traditional sort of chap, so I've started with the document 1 being the notification letter. It always features highly. Document 2, the British standards to be provided, the ICOMOS guidelines. Document 3, the extract from Olivia 1 would be document 4. And document 5, I'll package them as a bundle. I didn't know if you meant there was more than one authority that you were referring to.
And there's two, sir.
Thank you. So the plural was necessary. So document 5 will be a pair of authorities
Excuse me.
For the council's reference in opening. Thank you very much indeed. We'll keep that running list, although I do hope that we don't have too many additional documents still to come in. We have a fairly comprehensive 4-document list parties can refer to. Okay, I lied about 30 minutes, but that was partly in terms of trying to sort out the programme and others. Before I invite opening statements, any questions from anyone about what we're doing, how you will be involved? No? Good. Thank you very much indeed. Right, let me tidy my desk a little and then I'll invite opening statement. Mr. Banner.
I'm still tidying up, so I might ask Mr. Grant to circulate copies of our opening. We'll obviously get that uploaded online as well in due course. If anybody would like a copy, doesn't get a hard copy because we've run out, please just let us know in the break. Make sure you get a copy. So I start by noting that Basingstoke and Dean is a place where the national housing crisis is being experienced particularly acutely. It is, as you know, common ground that the council cannot demonstrate a 5-year housing land supply, and it hasn't been able to do so for at least 3.5 years. And even on the council's own figures, which we don't agree with, the position has deteriorated in the last year. It's now claimed to be 4.5 years housing land supply as opposed to the 4.83 it claimed in the Oakley appeal. The true position is in fact considerably worse than that. We say it is 3.71 years for the reasons given by Mr. Ross. Self-evidently, the council can't properly plan to address the shortfall unless until it recognises the true extent of the problem it has to deal with, which we say it hasn't. The affordable housing situation is even worse. There's almost 4,500 households on the Basingstoke affordable housing register, a substantial increase of 3037 from 3037 in 2016, 2017. So it's gone up by almost 1,500. Of those on the register, 102 have a verified local connection to Bramley. That's affordable housing alone, 102. For these reasons, amongst others, the ageing local plan is failing. It's not delivering, and it hasn't been for several years. And a new local plan is a long way off, even on the council's own timetable, which has already slipped once. It won't be adopted until autumn 2025. Now, against that backdrop, the council has no option but to accept, as it does, that the housing is going to have to come forward on unallocated greenfield sites outside of settlement boundaries. It's very surprising, therefore, that developers are still having to go to appeal on perfectly acceptable sites. A significant amount of the new major sites granted approval in the last year, give or take, have been granted on appeal. Now, Bramley is well placed to take a share of the need for unallocated greenfield development to address the market and affordable housing shortfalls. I note again, 102 on the affordable housing register have a connection to Bramley. The settlement contains, and the site is located in close proximity to, a number of services and facilities. It's well served by bus stops and a railway station. The appeal scheme before you has been carefully and iteratively designed, taking into account the key site constraints. And during this design process, the number of units is halved in order to make space both for the facilities identified in the neighbourhood plan and, importantly, for large elements of high-quality landscaping and public open space, over 16 hectares compared to a developable area of just 5.2 hectares open space, about 76% of the overall site coverage. The suggestion, verging on a mantra, repeated several times in the council's written evidence stating the case that the open space will have a manicured or managed character. It is unfounded and misconceived. As we will show you in evidence, the scheme design is high quality, it's attractive, and it fits with the current characteristics of Bramley. To the extent that parts of Bramley appear linear, and I emphasise the word appear, they will remain so. That appearance will remain. But it's not linear settlement. And even a glancing familiarity with Bramley demonstrates that. Now, we may well spend some time on landscape, given the way reasons for refusal are framed, but we ask you, sir, to remember this is neither a designated nor a valued landscape in planning policy terms. There will be some landscape and visual harm on site. We accept that, but that's an inevitable consequence as recognised in landscape statement of common ground of building on a greenfield site, which the council needs to do if it's getting close to meeting its housing needs. What's important, sir, however, is that the harm is highly localised in a visually contained site which is already on a settlement edge. And moreover, the scheme doesn't just minimise harm, it introduces a degree of betterment in the sense of there being new hedgerows, new community orchards, and an enforced obligation, as I mentioned, keeps 76%, more than 3/4 of the site, as an informal open space and landscaping, as well as the creation of extensive new habitats and the provision of access to areas with no current formal value for recreation. The council's heritage objection is highly exaggerated, and we ask you to take just as one example, just the purpose of opening it out, the allegation of mid-range, less than substantial harm, half the way to substantial harm, to the Church of St James's, half the way to knocking it down. This analysis lacks credibility for multiple reasons, including but not limited to the distance from the church, the extent to which there is intervisibility, and the fact that the council has recently permitted other developments significantly closer than is proposed here. Now, there are similar exaggerations and failings analysis in other aspects of the council's inheritance that will make them cross-examination in due course. Standing back, sir, standing back for the purpose of opening, we will suggest to you that the proper analysis is that the appeal scheme is in accordance with the development plan. The putative reasons for review, the ones that relate to the principle of the appeal, only cite 4 development plan policies, and that those are policies EN 1, 10 and 11 for local plan. 1 and 10 relate to landscape issues, 11 relates to heritage, and neighbourhood plan policy D1, which piggybacks on those essentially. Now, in relation to landscape, these aren't zero harm policies. These aren't policies that don't cause any landscape harm. If they were, any greenfield residential development would infringe them. The reasons outlined already, the appeal scheme is within their degree of tolerance, if I can call it that. Alternatively, to the extent that there are landscape-related conflicts with these policies, they're limited and they don't preclude a finance in accordance with the plan as a whole. In relation to heritage, such less than substantial harm as there would be to heritage assets, we say is outweighed by the scheme's public benefits. And for that reason, applying the local plan and the neighbourhood plan consistently with the framework, paragraph 202, there's no development plan conflict in this respect either. If you're against us on that, if you think that there is some development plan conflict, then of course we get into section 38.6 of tilted balance territory. And what we say there is that any non-accordance with the development plan is outweighed by other material considerations for the purpose of section 38.6, principally because applying the so-called tilted balance in paragraph 11D2 of the framework, which is engaged, firstly because it's a sub-5-year supply, and secondly because the paragraph 202 heritage balance is, we say, in our favour. Applying the tilted balance to the non-heritage issues after having gone through paragraph 202, the adverse impacts of granting permission would not significantly and demonstrably outweigh the benefits of doing so. The scheme will deliver a necessary and urgently needed contribution to unmet housing need, both affordable and market, in a way which doesn't undermine the character of the family. In many respects, the appeal scheme results in positive changes, the new community building, new skate park, new major area for formal park lines, significant net biodiversity gain, and significant economic benefits, all in a sustainable location. So for those outline reasons, of course, we'll elaborate as we go along the next 2 weeks. We'll, in due course, expect to invite you. Thank you very much.
Thank you, Mr. Bannon. Ms. Sargent.
Thank you, sir. This inquiry, as you've already informed us, has been convened to determine if the weight developments limited against the non-determination by the council of the appellant's application planning permission. And I set out in paragraph 2 the initial reasons for refusal even that were advised to the appellant in October last year. I'm not going to rehearse those. As I said earlier this morning, sir, paragraph 3, the council no longer pursues reason for refusal 4 or reason for refusal 5, and we accept that reason for refusal 6 could in principle be addressed through the imposition of a suitably wording planning condition, although the council doesn't agree to the wording proposed by the appellant. Reasons for refusal 7 will be addressed in the event that the appellant is able to execute a suitable planning obligation under section 106 of the Town and Country Planning Act 1990. But sir, for the reasons that I summarise in this statement, the other reasons for refusal, so 1, 2 and 3, remain well-founded, and the remainder of this statement deals in summary form, first with those reasons for refusal in turn, and then with the approach to be taken to the determination of the appeal before addressing the disposal of the appeal by way of conclusion. On the first reason for refusal in landscape and visual impacts, whilst the council agrees that the site is not a valued landscape for the purpose of paragraph 174A of the NPPF, It is a good example of countryside, and it is an important part of the rural context of Bramley Village, whilst also helping to shape the settlement outline. Public rights of way, including the Brenda Parkaway, a long distance path, run alongside 3 of the 4 sides of the site. And as illustrated in Dr. Hickey's heritage proof of evidence, the entire site falls within the setting of 1 or more designated heritage assets. As regards landscape character effects, the scheme would result in permanent adverse change to the rural character of the open countryside on the northwestern edge of Bramley, adversely affecting the settlement characteristics of the village. As Dr. Hickey's landscape evidence establishes, there would be a permanent, major, moderate, negative and significant level of change across the whole of the site, with a higher level of harm along the northeast of the site, where the major urban form within the scheme would predominate. Turning to visual effects, even at year 15, so taking account of the proposed mitigation, the scheme would result in permanent negative effects at key viewpoints, and those effects would range from very high to medium high in significance, except for one of them, which would be median, experienced by residents of the street. 5 of the important views that policy D1 of the neighbourhood plan requires to be protected, complemented or enhanced would instead be impacted by permanent adverse effects ranging in significance from medium high to very high. The scheme is therefore contrary to the neighbourhood plan and also to policies EM1 and EM10 of the council's local plan. Moving on to reasons for refusal 2 and 3, which deal with the harm to the listed buildings and the surrounding non-designated heritage assets, and also the harm to the conservation area. The scheme would cause less than substantial harm in the middle of the range to the heritage significance of the Church of St. James, which is grade 1 listed, and as you'll know, sir, is therefore a designated heritage asset of the highest significance pursuant to paragraph 200B of the MPPF. The scheme would cause less than substantial harm in the middle of the range with heritage significance of grade 2 listed Middle Farmhouse, and it would cause harm at the upper mid-range of less than substantial harm to the heritage significance of Stocks Farmhouse, again grade 2 listed, and less than substantial harm also in the middle of the range to the Bramley Conservation Area. So I add here that the council's position in this regard is not exaggerated at all. It is supported by the statutory consultee Historic England. Their position is that the scheme would cause harm to the significance of Stocks Farm, the conservation area and the church, because it would remove much of the wider rural setting to the listed buildings and conservation area and would reduce our appreciation of Bramley as historically a small rural village with strong agricultural ties. They consider that the scheme would have a significant impact on the Stocks Farm because it would remove all of its rural landscape setting. Historic England also consider there would be harm to the significance of the church because the ability to understand the church's situation on the northern edge of the historic settlement and its rural context would be eroded. And their position is that by building on open land to the north of the conservation area, the scheme would harm the significance of the latter. Historic England's view is that the rural setting to the conservation area is an important part of its significance, enhancing the character of this attractive historic village, which is unusual as it has not been surrounded by modern development. So overall, Historic England's view is that there would be less than substantial harm in the middle of the range of less than substantial harm. Great weight should be given to Historic England's advice as a statutory consultee, and there, sir, you see the 2 case law references that I referred to earlier this morning. The Secretary of State for Levelling Up Housing and Communities, in issuing his screening direction, noted that the importance of the wider landscape setting may likely have been underestimated by the applicant's assessment, and explained that he was of the opinion that developing on this land, as is now proposed, is likely to have a significant impact on specific historic assets such as Stocks Farm. He concluded that there were likely to be significant impacts, in particular to Stocks Farm. In accordance with, first, the statutory duty under Section 66(1) of the Planning Listed Buildings and Conservation Areas Act 1990, and secondly, Chapter 16 of the MPPF on the historic environment, considerable importance and weight must be given in the overall planning balance to the harm that the scheme would cause to the heritage significance of the designated heritage assets that I've referred to. The scheme would additionally harm the heritage significance of several non-designated heritage assets, and that harm must also be weighed against the scheme in the overall planning balance. As a result of the harm that the scheme would cause to the heritage significance of both designated and non-designated heritage assets, The scheme is contrary to local plan policy EM11 and to neighbourhood plan policy D1. The public benefits of the scheme don't outweigh the heritage harm that would result from the scheme. As such, consideration of Chapter 16 of the NPPF, together with paragraph 11D1 of the latter, indicates that planning permission should be refused. Turning briefly to reason for refusal 6 and the impact on the capacity of existing sewage drainage systems. As I've explained, the Council accepts that this reason for refusal could in principle be addressed through the imposition of a suitably worded planning condition, and our suggested wording is set out above paragraph 8.3 of the Sewage Statement of Common Ground. The wording proposed by the Council does not make any provision in respect of temporary arrangements. The Council's position is that such provision is inappropriate, and it notes that the planning condition imposed by the inspector in the lane of the decision did not include any provision in respect of temporary arrangements. So obviously the precise wording of the planning condition can be discussed in the inquiry section on conditions. I turn then to the approach to be taken to the determination of the appeal. Section 38(6) of the Planning and Compulsory Purchase Act 2004 requires applications for planning permission to be determined in accordance with the statutory development plan unless material considerations indicate otherwise. The scheme doesn't accord with the development plan, it conflicts with it. In those circumstances, Section 38(6) of the 2004 Act requires planning permission to be refused unless material considerations indicate otherwise. They do not. The NPPF is an important material consideration. Applying paragraph 11D, the policies which are most important for determining the application are deemed to be out of date here because the Council can't demonstrate a 5-year housing land supply. However, paragraph 11D1 is engaged because the application of the NPPF's policies on designated heritage assets does provide a clear reason for refusing the scheme. That is because the public benefits of the scheme don't outweigh the harm that it would cause to the heritage significance of the relevant designated heritage assets. The Council acknowledges the benefits that the scheme would secure, and this is dealt with in Mr. Dawes' proof. In particular, the Council gives considerable weight in the overall planning balance to the market housing element of the scheme and significant weight to the affordable housing element of the scheme. And it does so even though the Council considers that the current shortfall against the 5-year housing land supply requirement is moderate, being on the Council's case a shortfall of half a year. And even though planning permission has already been granted for significantly more than the local plan requirement of 200 units for Bramley. Nevertheless, even giving that weight to the housing elements of the scheme, on a proper understanding of the harm that the scheme would cause to the heritage significance of the church, which is a designated heritage asset of the highest significance, and to Stocked farmhouse and Middle farmhouse, and according the requisite considerable importance and weight to that harm, it is clear that the benefits of the scheme do not outweigh the harm to the designated heritage assets. And so even if paragraph 11D1 did not provide a clear reason for refusing planning permission, the appeal would fall to be dismissed pursuant to the application of the tilted balance of paragraph 11D2. Taking the harm to the significance of designated heritage assets, together with the landscape character and visual harm, and the harm to the significance of non-designated heritage assets, the adverse impacts of planning permission would significantly and demonstrably outweigh the benefits of granting it. Overall, therefore, the scheme does not accord with the development plan, and material considerations do not indicate that planning permission should nevertheless be granted. Planning benefits of the scheme, whilst acknowledged, are insufficient to outweigh the substantial adverse effects that the Council has identified in its evidence, nor do they succeed in outweighing the conflict with development. So for those reasons, in summary, permission should be refused for the scheme, and the Council respectfully invites you to dismiss this appeal.
Sergeant, thank you very much indeed.
So can I just flag up one point now, just in case it gets lost between now and we do the training? It said at the end of 16 that the Clappers Lane decision didn't include any provision for temporary arrangements. Worth just noting, because I was counsel in that case, the inspector wasn't asked to make any provision for temporary arrangements. So the issue of temporary arrangements simply wasn't in play in that case. Just to flag that up now, because I might forget mid next week.
All right, thank you very much. I'm we're at 10 past 11. How does it sound if we took a 10-minute break? I was going to say 15-minute break. I made the error when there was quite a large number of people in the room saying 10-minute break. It was where there was a Starbucks nearby, and I didn't see people for about 25 minutes because I was stuck in the queue. We'll take a 15-minute break, then I'll come to you, gents, to give us your statement. I think we would start with Mr. Khan. Oh, I broke too late, as it were.
Starbucks.
I think we'll take a 15-minute break, then I'll come to you, gents, and Mr. Khan, I'll give you the opportunity to go first, but it gives you a chance to have just a brief respite and a chance to come back. We're just coming up to 10 past 11. If we come back at 25 past 11, okay, and then I'll take Mr. Khan. We have a witness table set up there. We've got the table here. Perhaps just put a chair there. Perhaps we can make statements from the position here. Might be easiest.
The microphone though. So.
Oh, you're right. We might have to ask you to come all the way down to here to pick up the mics. All right, thank you very much. I'll see everyone back here at 25 past 11, and we'll take the statements from the interested parties. Thank you very much. Can I ask, do you find it a bit stuffy? Ladies and gents, welcome back. 2025. As I previewed before the break, a chance to hear from interested parties to take the long walk. Mr. Coates, I did suggest that you would come first, but there was some discussion about an order amongst others. You've got an order, have you?
Yes.
Khan, apologies. Excellent. Mr. Khan, do you want to come? Okay, I've switched my microphone off, so pressing the button on yours should wake yours up. There we go. Excellent. Mr. Khan, welcome. The floor is yours.
Thank you very much, sir. My name is Mark Khan. I've been a resident of Bramley for 17 years, and I live at Stocks Farm House. And I know that that's been already discussed this morning, and I'd be very welcome for you when you do the site visit to visit the Stocks Farm House, and I'll make you a cup of tea, and you can see for yourselves the issues there. I'm currently retired, although I am the chairman of a local infrastructure tunnelling business. My previous job was as the chief executive of Network Rail, a job that I retired from 4 years ago. So I have a relatively short statement, which I can give you a copy of afterwards. Communities should be at the heart of planning. That means that local people should have a greater say on where and where not to place development. These are not my words. They are those of the Secretary of State for Levelling Up Housing and Communities, Michael Gove, when he launched the Levelling Up and Regeneration Bill in December 2022. He also said, if we are to deliver the new homes this country needs, new development must have the support of local communities. So does the Stocks Farm development have the support of the local community? No, it certainly does not. Over 200 objections were made to the planning application, and the Village Hall event organised by the Parish Council to discuss the application was packed, standing room only, and only one person present was in favour of the development. And if local democracy is important, then surely the local neighbourhood development plan, built from the views and wishes of the local people, should be adhered to. The latest draft plan states that Bramley should have 55 more houses only between now and 2039. Now, let us be clear. The 200 specific objections and the local neighbourhood plan objections are not NIMBYism. Bramley has already taken over 350 new houses in the last 10 years. The very nature of the village is already under threat, and that is not what sustainability is about. We have done our bit. This development should be rejected on the sustainable development principles that underpin the National Planning Policy Framework. The current infrastructure, whether it be schools, doctors, or sewerage, is full. It cannot be sustainable to have to build new facilities in Bramley when there is spare capacity and infrastructure elsewhere. Finally, I am extremely concerned about the lack of town planning regarding the level crossing, the railway level crossing. According to Network Rail's latest strategic plan, the freight rail traffic through Bramley is expected to double or even quadruple in the next 20 years. Now, this particular railway is extremely unusual in our country because it's a freight and an intercity through route, as well as providing a local stopping service. And there are no passing loops or anything like that. The planned increase in rail traffic will make the level crossing, which is already a significant road and pedestrian bottleneck, essentially impassable for unacceptably large amounts of time. This already causes people to use the right run down the dangerous and unsuitable single track Minchin's Lane and then past the primary school. So a solution to this problem is obviously essential. But who will provide it and when? Not Network Rail. They plan the railway infrastructure only, and they've no plans to change the level crossing. Now, present and future generations can only be protected from this planning failure if the planning authorities, the inspectorate in this case, require road and rail authorities to produce an integrated, joined-up plan that can meet the needs of both today's and future generations. Now, it must be stressed that any planning approvals given now reduce further the options for potentially bypass roads and massively increase the cost and environmental impact of potential alternatives to the level crossing. And this would clearly be a waste of natural resources, increase pollution, and contribute to climate change, all completely contrary to the MPPF's Sustainable Development Goal. For all of these compelling reasons, this planning proposal should therefore be rejected. Thank you very much.
If you press the button, Mr. Khan. Mr. Khan, thank you very much. I tend to ask people when they sit down whether you're content with just making a statement or if it was whether you wish to ask questions of later witness. And in the interest of fairness and impartiality, if you do want to question witnesses later, then you need to be prepared and willing to have your own evidence tested by questions potentially from the appellants. Are you content to be questioned? Is it just a statement that you wish to leave me?
No, I'm very happy.
It does get confusing.
I'm very happy to be questioned on the issues that I've raised.
All right. Mr. Bannon, did you have any questions then for Mr. Khan?
No, I don't, not because we agree, but in the interest of proportionality, generally my policy, I'll let you know if not, but I expect my policy throughout will be we'll deal with them in our own evidence, which I think will be more helpful to you.
I fully understand. It's the standard part of the process and an expected response. Do not worry. Mr. Khan, thank you very much.
Yep.
Right, from the parish council, I had Mr. Flukes and Mr. Bell. You don't necessarily have to come up as a team, but it's up to. Okay. Welcome. If you just want to introduce yourself and then the floor is yours.
Yeah, good evening. I'm Councillor Chris Flux. I'm chair of the Bramley Parish Council Planning Committee. Here to represent the views of the residents of Bramley to this development, particularly the 257 who objected on the borough website. Our neighbourhood plan was developed was made in early 2017 and was supposed to see us through until 2029. It covers the entire parish of Bramley and called for us to accept at least 200 dwellings. This figure was derived from the demonstrated local housing need. Since that time, we've had 421 dwellings built or in the process of being built. We also have outline and detailed approval for a further 358. For a village with limited facilities, that's an enormous number in a short space of time. The reason is always that there is no demonstrated 5-year land supply. It appears to many of us that this is a grossly unfair imposition onto the village. Our major concern is the fragile state of the sewage network, which has been showing signs of distress since about 2009. Really came to a head with the occupation of Centenary Fields in February 2021, which included bubbling up of water into shower trays and kitchens in new build homes, and wastewater escaping from manhole covers. Our exchanges with Thames Water are itemised in the Parish Council website entitled Bramley Sewage Issues. I have a copy of that if you'd like it. We also have later communications from James Hearn, Senior Project Engineer in Development Services, in which he states the system is unable to accept the flow from this proposed development. From these documents, you will see that while we are somewhat sceptical that imposing planning conditions will do anything to alleviate our problems, even if and when the village system is upgraded, it will merely mean pumping at a greater rate to the Sherford-on-Loddon treatment works. These works are often overwhelmed, thus pumping untreated effluent into the River Loddon. And the idea of tankering waste away in the 21st century is wrong. I'll leave it to my colleague, Councillor Malcolm Bell, to itemise our objections on other parts of this application. Thank you.
I have copies of this, would you like?
Yes, of course. We do need to have copies for the other side as well. Thank you very much indeed. Sorry, Mr. Bell, this is your presentation.
This is my presentation.
Thank you very much.
Thank you. Excuse me. My fellow councillors put figures to the extraordinary expansion that Bramley has endured over the past years and highlighted but one area of the infrastructure that is a great concern to the community on the quality of life. Excuse me. To health issues. Bramley Parish Council is not against expansion, but with the backing of the community, put together the neighbourhood plan that would see Bramley grow in a manner that would not destroy its rural nature and its historical past. The policies of the plan were written with this in mind, to achieve the vision for Bramley that is going out to 2029 for the same period of the local plan, that Bramley will be an attractive village with strong historic character, an unspoiled rural setting, excellent and conveniently located community facilities, a range of high-quality homes fulfilling local needs, safe and convenient access to transport services and green spaces, and good opportunities for locally based employment. The neighbourhood plan and its vision was praised by the inspector in accepting the plan as being comprehensive and achievable. The policies, as said, were written to achieve this vision. Such policies are Policy H1, New Housing Development. The purpose, as paragraph 6.17 of the plan, to provide opportunities for sustainable future housing development which does not encroach in open rural areas with certain defined except. Could I get a drink of water, sir?
Of course.
Excuse me. Thank you. To ensure the potential future housing development contributes towards the local services and facilities. Policy D1, protecting, complementing and enhancing the historic character and rural setting of Bramley. The purpose, as per the 6.56 of the plan, to protect and enhance the distinctive rural and historic character of Bramley and to ensure that important views in Bramley are not impaired by future development. These are two of the policies which are there to achieve the vision of Bramley. The policies are not there to stop housing, but the developments have to be in accord with the policies. The development does not go anywhere near being in accord with the neighbourhood plan and the wishes of the community who want to have a good quality of life in a rural village. The objection Bramley Parish Council submitted at the time of the pre-application after an open meeting with the community highlights the problems facing Bramley and how this application fails to complement the service and facilities in Bramley. The rural aspect of Bramley is important to the residents of Bramley and needs to be maintained. Just looking at policy D1, which refers to important views. The important views are identified in Appendix D of the neighbourhood plan and shown in illustration 6C. I have a copy of that for you, sir. Of the neighbourhood plan. This is for the area under consideration where there are vista views into and out of the area up for development, distinctive rural views. Not only are these highlighted, but from the surveys in preparing the neighbourhood plan, then the community highlighted what they consider are important views. This area is part of the rural views of to the north of the conservation area. The undulating landscape and historical history of Bramley, agriculture in nature which continues in this area because it is good agricultural land that has been worked for generations. It has historical significance, the agricultural history with Church Farm, a working farm to the southwest corner of the site. Walking across the area from James's Church and the conservation alongside the area to join Brendan Parkway, along the path on the southern border of the land, there is an essence of complete peace with nature, agriculture and wildlife in the area, badger, foxes, roe deer, besides birds, kites and barn owls. These views will be lost forever with this housing development, which is to the detriment of the quality of the life of the residents. This area has not only highlighted in the neighbourhood plan for its views, but is highlighted in the Basingstoke and Dean conservation appraisal for Bramley and Bramley Green. Having designated the conservation area, then the local authority has a statutory duty to ensure that those elements that form its particular character or appearance should be preserved or enhanced, especially when considering planning applications. The document was adopted as a supplementary planning guidance by Basingstoke and Dean Borough Council on the 17th of July 2003. The plan identifies buildings, views and key features considered essential to the special character and appearance of the conservation area which borders the western corner of this site. The views into the area are the vista views, which are considered important in the conservation area appraisal, given the wider landscape setting. This is besides the important rural landscape views highlighted into and out of this area through the neighbourhood plan. Through the west corner of the land runs the remains of the Roman road, which runs north to south. Grade 2 listed stocks farmhouses situated immediately east of the upper eastern land boundary. All will be lost as a result of this development. Bramley was asked to review by Basingstoke and Dean for the local plan what it considers are important local green spaces. This area was put up for development along with three other areas, once considered to be of such significant importance that the site was promoted to be a local green space. It is not necessary development because this housing development is not contributing to the housing requirements for Bramley, which has been met by the present housing development. As always, it would be highlighted as the shortfall in the 5-year land supply and the contribution made to the housing shortage in the borough. But have the likes of Bramley to be sacrificed, giving up its green open spaces, its historical background to achieve housing numbers. These rural settings can never be recovered once bricks and mortar take over. It will be said that the neighbourhood plan cannot be considered because, again, the shortfall in the 5-year land availability. But in doing so, you are ignoring the wishes of the community who live and work in the area, who have bought houses in the area because they want to have a life in a rural village setting. Bramley Parish Council has commissioned surveys and comprehensive studies of Bramley to include a review of current housing services and infrastructure provision. These are all listed in the report Future Development Challenges, which is available on the Bramley Parish website. The consistent conclusion is that Bramley is not sustainable to have further housing without due consideration to the improvement in the infrastructure of the area and due consideration to the historical and rural setting of the village. The shortfall in the infrastructure is comprehensively covered in the report from the Parish Council. Bramley Parish Council has consistently highlighted the problems associated with the infrastructure, Basingstoke and Dean Borough Council, in its efforts to preserve the quality of life that its residents deserve. This development does not in any way go towards enhancing the quality of life of Bramley residents, but goes a long way to taking away its historical rural setting which its residents treasure. This development has to be rejected. Thank you, sir.
Councillor Bell, thank you very much. Mr. Banner, anything?
Same answer.
Thank you. Don't worry, I have, as part of the core documents, the neighbourhood plan. So I have the views that you refer to.
You have the views referred to.
They're in the core documents.
It is number 6C.
Yeah.
Okay, fine. Thank you, sir.
Do you have it's from our website?
No, I don't. Do you have copies for?
No, I've read my print out.
We will ask the council just to get a set of copies done. If you wish me to have a copy of that.
So we have to have copies for.
You always have to have copies for everyone.
Okay, well,
I'm sure that the council, as we're in the offices, can facilitate that relatively simply. Thank you very much indeed, gents.
You may not have these, sir, which I referred to.
Remind me what that is.
Future development challenges, which gives a list of the reviews.
If it's something that you wish the inquiry to have, please do. But I need to have copies for all.
Yes.
For the main parties.
Yes, the main parties as well, sir.
Oh, you have some copies of this one
Yes, I
directly,
have.
do you? I think it's Mr. Banner needs to have one. Oh, you've got some. That's fantastic. Thank you.
That is the one which I referred to regarding commercial and local green space.
Yes. Thank you very much indeed. Sorry, you just handed me another one. What was that one? Oh, this is the local.
The promotion I've made, you made as Prime Parish Council for this area to be local green space.
Okay. Sorry, Mr. Van, did that one come through to the appellants too?
I think so. This is the local green space.
Local green space. Yeah.
We have what I think we have possibly have. Oh no, I've got some. My bad. I've got two. Here we are. Perfect. Thank you.
So I'm just keeping up with my paperwork for a moment there. I've dropped those three in as documents, well, actually with Councillor Bell's statements, documents 8 to 11, so that we're on top of that. So the local green space ends up in document 11, and I'm sure we'll have copies of the sewerage statement that's going to come through from the council, and that would be document 9 within that process. Thank you very much, gents. Right, our district councillors, we have. Yes. Councillor Robinson, Councillor Durham, and Councillor Tumblin. Very good. Press the button and then on the microphone, and then introduce yourself. And the floor is yours.
Thank you, sir, and thank you for the opportunity to speak. My name is Councillor Nick Robinson, and I'm one of the 3 councillors for the Bramley ward in which this application sits. I'm also chairman of Basingstoke and Dean Development Control Committee. Parish Council representatives have given you details of the detrimental effect this will have on Bramley and its residents. I will not waste your time giving you chapter and verse of what you have already heard from them. However, I am in full agreement with everything they have said. The only reason we have this application before us today is because we do not have a 5-year housing land supply. Like most councils in the southeast of England, we have found it an impossible target to maintain. However, Basingstoke does deliver in excess of the housing target. Over the last 15 years, Basingstoke has delivered an average of 899 homes per annum. More recently, in 21-22, 809, 2021, 1,241, 19 and 20, 1,556, 18, 19, 1,200, and 17, 18, 828. This gives Basingstoke and Dean a homes completed average of 1,120 per annum over 5 years. Basingstoke has exceeded its delivery target by over 31% and is projected to exceed it next year. Even applying a tilted balance, Basingstoke does not need these houses. We have over 7,000 extant planning permissions undelivered in the borough. This is caused by developers not bringing forward sites due to market or operational conditions. Bramley. Bramley was asked to provide 200 homes in this planned period. It has delivered 351 in close proximity to Stocks Farm. The local plan inspector said Bramley has done its bit. In addition to all this, 700 have been approved at Racers Farm and Upper Covered Farm within the parish of Bramley, but outside the settlement policy boundary. 1,041 in total over the last 10 to 15 years, plus a smattering of single house developments, taking the total over to 1,050. As I've said, Basingstoke does not need these houses. Bramley certainly doesn't. Thank you for your time.
Thank you very much. Was it Councillor Tamblyn?
Thank you, sir. Tomblin, actually, Tomblin.
Tomblin. Yeah.
I've been called many things. I'm sure that won't stop. I have actually got 3 copies of my evidence. Would you like me to get those?
Very good. Saves me scribbling. Thank you.
There we go. Can I ask you? Thank you, sir, for allowing me to speak today. My name is Chris Tomblin. I am a retired chartered engineer and both a borough councillor of Bramley and a member of the Bramley Parish Council. I'm also a member of the Borough Development Control Committee. I've lived in Bramley for over 30 years and I've personally witnessed the unprecedented growth of the parish. So the applicant Waits Home has chosen the route of an appeal to gain planning permission, which has meant that the Section 106 agreement procedures that the borough adopts has not involved we, the local ward councillors, and that's at the heart of the borough council's policy. So we've been kind of left out. As written down, the reason refusal number 7 states in the absence of any suitable legal agreement or justification of the absence of a legal agreement, the proposed development does not make adequate provision for community and infrastructure contributions in relation to affordable housing allotment provision, off-site playing fields, on-site open space, play facilities, public art, landscape management, biodiversity, public rights of way, and the travel ban contribution. Well, as such, we are now presented with an applicant's version of what infrastructure contributions would be of locally agreed benefit rather than those worked with council and local people. So what I want to do, if I may, sir, is just go through Bramley's infrastructure to give you a picture. The plain truth is that the current lack of infrastructure means that Bramley falls a long way short of being able to support any more homes. As you've heard, the current local plan required Bramley to take 200 homes via neighbourhood planning, which then became at least 200 homes, and 350 plus have been delivered. And that doesn't include those 2 major sites to the south of the borough. And all of those have failed to upgrade any of the infrastructure in this village. The draft policies in our stalled but emerging local plan, they calculate 55 homes would be necessary via neighbourhood planning from between now and the end of the plan in 2029. So only 55. This development proposal, therefore, makes a mockery of these numbers, both its current adopted plan and the neighbourhood plan. You've heard about sewage. The Thames Water have been engaging with Bramley Parish Council and ward councillors with regards to ongoing flooding and sewage issues. Since the construction of the Centenary Fields estate of 50 houses, that's to the east side of the railway crossing, we've experienced sewage flooding into their domestic properties in heavy rain. Thames have investigated the causes. The sewers run from the west of Bramley to the east and onto Sherford-on-Loddon water treatment works. There is a history of older developments in Bramley which discharge rainwater into sewers, and further leaks, the source of which is currently not known, which all cause the sewage capacity of the system to be exceeded. A pumping station was installed alongside the street in the 1990s, but this has holding surge tanks which fill up. The pumping equipment installed is unable to deal with the flows of the incoming water whilst trying to empty these tanks, thus we get overflowing. The main sewage pipes do not have the capacity to take the volumes of water from the existing home, thus the recent additional developments that Bramley has seen. There needs to be an upgrade of these pumps and a new mains pipe installed to carry the flow to Sherford-on-Loddon water treatment works. Thames have indicated that this project would be at least 3 years away from when funding is agreed. Until then, they do not support any additional homes being served by the existing sewage network. Should this development be approved, it must not be delivered until that project has been completed. Any short-term solutions offered would not be seen as temporary, not for 3 years. Tankers would be a totally unworkable solution given the traffic conditions within the village, and quite frankly, it would be seen as a third world non-sustainable solution. So let's look at transport. Bus provision. I think we heard that we have a number of bus stops. That's very true, we do, but we don't have many buses to actually stop at them. The number 14 is the only service. There are 8 buses a day between Bramley and Basingstoke bus station, each way, but they're at irregular times, from 7 a.m. in the morning and the last bus back at 6:40, 35-minute trip. There are 3 direct buses each way to Tadley, which is another northern conurbation where there's employment, all in the middle part of the day. The journey is 25 minutes, but by taking 2 buses, you can leave at 7 a.m., but it takes over 80 minutes to get to Tadley. So to get to the hospital, one has to change at the Basingstoke bus station. Therefore, people in Bramley rely on the private car, which is becoming unsustainable. Yes, we have a railway station. So we have a train service. There are 38 trains a day, 6 a.m. to midnight to Reading and 37 from 6 a.m. to midnight to Basingstoke. However, previous residents' surveys, when building the neighbourhood plan, etc., indicate approximately 10% of the Bramley community make use of the train. These are mainly commuters, as the train does not take people to the local supermarkets or to the many retail parks within the borough. Our roads. We've heard there's a level crossing on the main road. It's closed 35 to 40 minutes each hour, as the line has a shuttle train, a freight service, and cross-country trains. Now, this causes queuing on the only through road, which will build back with over 250 metres of queues quite frequently, more than 40 cars each way. The queue will not often clear before the next train, and the main route to school crosses these queues at the railway station. Network Rail are unable to provide a suitably accessible footbridge due to space and cost constraints. This means that pedestrians have to wait considerable times in all weathers to cross the line, there being no other crossing within the village. The main route to the school from the east side of Bramley has to cross the main line, and the delays to pedestrians result in them preferring to use the private car. Then the narrow local lanes are busy rat runs, with vehicles trying to avoid the queuing. The C32 is the classification of the main road through the village, which has to handle traffic from the A33 across to the A340 as the only crossroad link north of Basingstoke. Heavy goods vehicles are common using this cut through from the north of the borough. When the A33, which is at capacity now, has any issues, it's getting more common than ever, even now, right as we speak. Traffic is diverting through Bramley and along the street. To access Basingstoke, traffic will avoid the congested A33 and it will divert through the village and down Cuffoyd Lane to the business parks on the lane or down at Chinham. It will also use Vine Road towards the Basingstoke Hospital. The trips via these roads are actually shorter than the A33, but they're single track in places and angry queues often build up. This development's proposed location will result in an increase of use of the car as the main means of convenient transport. The shift to online shopping and supermarket delivery will see an uplift in delivery vans using the C32. The site entrance is also located on the stretch of the C32 that suffers from speeding issues. The local Speedwatch team has recorded maximum speeds of 72 miles an hour, and over 40% of all vehicles are travelling in excess of 30 miles per hour. Parking in the village is an issue. There is no station car park. There's a small 23-car space Basingstoke Dean and Borough Council owned site just along from the station, which is full by 7 a.m. in the morning, all day with users. So all other cars park on local roads, which causes traffic flows to become inhibited along the C32. Briefly looking at shops and the retail offering. To serve the 5,750 people, that's the local 2021 census of the population, we have a small convenience store with a post office, a Turkish barber, a bakery and a small cafe, an estate agent, a public house, and a motor repair shop. So that's hardly sufficient, and therefore it encourages much travel out of the village. Community facilities. Bramley does not require any more community buildings. The village is served well by the village hall and Cliff Meadow, which has 2 community buildings, and Cross House at St James's Church. All of these are challenging to keep funded and maintained. We don't need another one. The school is a primary school, 3 form entry, with pupils being bussed in already from Sherford-on-Loddon. The school can cope with what Bramley has now, but the headmaster has said it will need to expand to take more children. The catchment secondary schools, they're more than 4.5 miles away, and all students have to travel to attend. Many students travel much further to access other Basingstoke schools. The health and the doctor's surgery. Well, the current Clift surgery, which is in Minson's Lane, adjoining this site, is now too small to serve its catchment area. It requires funding to expand its building to cope with the extra numbers of residents in Bramley. It has commented that it must do work to see how it can maintain support of its current numbers, let alone take an increase in potential patients. So, what has this developer offered the community from its brochures in the absence of any discussion or involvement with borough and parish councillors, or indeed the 106 officers, as far as I'm aware? They intend to provide a community building with caveats, a 250 square metre building ready to fit out with services by the 100th dwelling, i.e. after 70% occupancy, rather late in the day. Market the building for potential occupants for a minimum of 2 years, and if no occupants are secured within 2 years, then it will be turned into residential purposes. So that's not really a great offer. 76% of the site will be provided as public green space. Provision of allotments. Who will manage these? We have no idea. A community orchard. This is interesting. Who will manage this feature? Leaves and old fallen apples and pruning every year. Who will do this? Who will pay? We have no idea. The applicant has also provided a fanciful travel plan to justify how reliance on the private car might be reduced, with such highlights as a £75 voucher for every household, the first owner of the dwelling, to be able to choose from such things as buying a bicycle or bicycle training, a £75 voucher toward bus or rail travel. So not great offerings. So I'm afraid that none of these offerings, which may or may not happen without the Section 106 agreements fully agreed by all parties, will address the lack of the infrastructure that I've outlined. New residents of this site will suffer these frustrations, which will have been made worse, sadly, by their development coming forward. So therefore, sir, I do urge you to dismiss this application. Thank you very much.
Councillor Tomlin, thank you. Ben?
No, I same answer.
I'm assuming matters are going to be picked up by, some of those matters picked up by transport, some in discussion at the unilateral.
And some by Mr.
Session.
Right.
Just for you, Councillor Tomlin, and for others, I have asked that Mr. Bevis has produced proof of evidence on transport matters, because transport matters are quite a lot of what you've just made statement on. And at the moment, the programme anticipates that he will be addressing the inquiry on next Tuesday morning. I'll have questions that I'll try and capture from the comments that I've received from others, but I will offer the opportunity to put questions to Mr. Bevis from the parish or as ward councillors if you wish to do so. And that's why the programme is quite important if you wish to engage in that. So keep an eye on the progress of that.
Absolutely. So if I can add as well, though Mr. Bevis isn't here today, Mr. Grant's taking a very good note, and we're going to communicate back to him the comments that have been made so that he's well versed in your concerns.
Thank you, sir.
Thank you very much, Councillor. I think that leaves us with the last but not least, Councillor Durrant.
Excuse me.
Councillor Durrant, welcome. If you want to press the button, the floor is yours.
Right, thank you for giving me this opportunity to speak. I am the third of the wise men you've just seen, and I'm wise enough to know not to repeat everything in detail that's been said before. So mine will be a brief summary of where we stand on our views on what we determine as the landscape impact. One overall statement to start with is that this development is outside of the SPB, therefore in the countryside, and there is no identified local need for these dwellings. There is an adverse impact, as you've heard, on the setting of the southwestern conservation area, views in and out of the area, and particularly the long view from the east towards the church spire, which is a typical rural village scene and much appreciated by the residents. The development would have a significant adverse impact on the setting of the Grade 2 listed building at Stocks Farm. It would have a similar adverse impact to the Grade 2 listed building of Middle Farm and the adjacent notable buildings. And their setting and context is obviously important to the rural nature of the village. It will have an adverse impact on the setting and views from the Brenda Parker Way and the other footpaths that run through Middle Farm in all directions. Important rural views and vistas has Councillor Bell identified in Appendix D of the Bramley Neighbourhood Development Plan and Borough Conservation Appraisal document. It is a loss of good agricultural land when at a point in which we need to secure our food supplies going forward as a country. It will damage the established existing biodiversity balance. There's no doubt about that. One appreciates that you can set up new incoming biodiversity, but it's generally at the expense of the existing biodiversity, which has taken possibly centuries to establish. There are a number of policies across the local plan and the neighbourhood development plan that this development would be at odds with. And I'll just list them. They're all in the documents that you've got already. All the participants have, but I'll just list them. It's H1, H2, D1, RE1, T2, SS5, SS6, CN6, EM1 and EM7, which is a sizable list for any development to impact. That's all I have to say, to be honest. It's a brief summary to bring things together on landscape. Thank you.
Councillor Durrant, thank you very much.
Usual answer, sir.
Thank you.
Thank you. By my reckoning, there's an outstanding document then, which was the sewerage document from the parish council.
So I have already unsurprisingly, because this always happens to me, fallen behind with my list of inquiry documents. I got as far as number 5, and then I guessed that 6 and 7 were our openings.
I'll bring you up.
Then I now have and I am very grateful to the third parties for bringing paper copies, because often people don't realise that's helpful. So that is very helpful, but it does mean I have a small stack that I don't have numbers for already. So to save us, or me, having to ask you to read through a list of 60 documents in due course, I don't care any of that number, but would you mind just filling me in on where you have got to, so that we're all on the same page, please?
No, absolutely no problem at all. You're absolutely right. 6 and 7 were the opening statements. 8 was Councillor Bell's statement. 9 is the anticipated sewerage statement. Future development challenges from the parish council was 10. Local green space promotion by the parish council was 11. And then we had Councillor Tomlin's statement that I have as 12. So as I say, I think 1 outstanding.
I have been handed what I think is the sewage documentation. Right. I don't know if the appellant.
We haven't known.
Yet.
Yes, we've given that.
Could we have more than one copy if possible?
Yeah, it's one by Jim.
If we could possibly. Thank you.
Thank you.
Is that one?
Okay, sorry, let me just check what additional ones I have here. Are they all part of this package of sewerage things? Just so I check that I've got what I'm expecting to have then. Bramley sewerage issues. An email from James Hearn. I assume that's Thames Water's email that you referred to. Statement on foul water capacity from Thames Water. And a Councillor Bell, it looks like a message to you from customer feedback. So that's all part of the package. And hopefully the appellants have got that set of 4, which will bundle up as document 9. Good, thank you very much.
So may we, before the potential interested parties potentially disappear, could we discuss the programme again? Because it may be that there are consequences to that discussion that they wish to know about in terms of when to turn up. Mr. Sergeant and I had a brief discussion about the design issue earlier and didn't really make a huge amount of progress. I think our concern is best put this way, so that if Mr. Burton's evidence is contested, then the council must have somebody who's contesting it, and that appears to be Mr. Dawes, and therefore that evidence ought to go before Mr. Burton. If Mr. Burton's evidence is not contested, then that would be great. I'd like to know that, and we can stand him down, subject to potentially any questions from you or the third parties. But the council can't really sort of sit on the fence. It's got to be one or the other. A welcome confirmation of that. If it is contested, then if there's a very strong disinclination to call Mr. Dawes twice, say in relation to housing and supply, then the only alternative would be to bump Mr. Burton down until next week, so that we would hear landscape and heritage this week, which may actually enable us to get Stoughton done in full, effectively. So maybe a windfall in this respect. And then next week it would be Mr. Dawes giving his planning evidence after the various other stuff before that, followed by Mr. Burton and then Mr. Ross. But what clearly wouldn't be appropriate, and actually would be unfair, would be for Mr. Burton to give his evidence, it being disputed, yes, and then the council's evidence in response being afterwards. That would not be right.
I haven't had opportunity to ask Mr. Dawes. I did say this morning I would need to speak to Mr. Dawes about it, and I didn't have time in the rush, the short break earlier to do so. But to avoid further debate on this, I'm just going to answer for us as a party. It's not correct to say that the council can only dispute the appellant's evidence if it has a witness that is producing, evidence that directly goes to the same issues. You've all had your own experience of six parties, for example, coming along and questioning an appellant's case without necessarily fielding their own witnesses. But so I don't accept that Mr. Dawes somehow has to produce evidence that, matches Mr. Burton's evidence, because they both produce their own proofs and they may have approached the issues from slightly different angles. But to avoid any debate about recalling witnesses, I'm happy to essentially carve out whatever evidence in chief I was going to prepare in due course on that section 4A of Mr. Dawes's proof, and to take him through that in advance of Mr. Burton's evidence. But I do make clear that I don't necessarily accept the way that the evidence has been characterised by the appellant, but that's something I can pick up in closing submissions.
I agree that you won't always get an exact pairing of evidence between the parties, but I do understand the point that if there is a challenge from the council to the arguments put by Mr. Burton, that challenge needs to be vented prior to Mr. Burton taking the stand in the inquiry. I have no particular concerns if that had to happen next week for reasons of preparation time or whatever might be there, although I think it is neater if we can keep the landscape and design elements together this week. I think it's entirely fair you have the opportunity to think this through, because it wasn't a bombshell when it arrived this morning, but it was something new that we needed to address and deal with. And certainly I'll make sure that we have a longish lunch break in order to perhaps get some of these things bottomed out so we can agree them when we come back after lunch. I don't think it's insoluble. I think there's a solution. Your early solution seems like a way forward if it deals with section 4A of Mr. Dawes as an in-chief element that Mr. Banner can have a chance to test him on, and then Mr. Burton can have a chance to bring his evidence forward that you can then challenge on.
I have no particular difficulty with the proposed timetable. It's really any sort of passing comments about who is saying what and who is giving what type of evidence. I just don't think that's something we need to deal with in a debate over timetabling, and I'll come back to those in submissions if we need to. So I don't have a difficulty with the timetabling. I'll have to find some time to do a little bit of evidence in chief sooner than I was planning, but that's not going to take very long. I have understood that the section of Mr. Dawes' evidence that Mr. Banner is concerned with is section 4A, and I'm sure if there's anything else that I need to be focusing on, he'll let me know, but unless I'm told otherwise, that's the section I'm going to prepare.
I'm sure that it's 4A because I think every other section does refer back to Dr. Hickey's from my memory of reading it through.
That's my reading of the proof.
After lunch, then we'll have a way forward, hopefully, on that, following a little bit of
Thank you both.
further discussion. The reason we're having this discussion is because I think rightly, with the concerns expressed by the parish council and district council, the offer is there, they may wish to both listen in and perhaps even have questions that they might want to put to the transport evidence of Mr. Bevis in particular. We haven't fully decided what we're going to do with Mr. Brackley and the drainage evidence, other than suggest initially that was done in conditions sections. I think leave that one with me. That's something I think for me to have a bit of a mull over. And I'll give you some feedback on that, because as I understand it, the council's position is not challenging the evidence, but challenging the methodology by which a condition would address sewerage problems in the district. Is that fair? I think it is.
Yes, sir, it is. The particular concern the council has is simply, how kind of rigorously worded the condition needs to be, and whether there should be express provision for a world in which temporary arrangements are permitted under the condition. We say, no, that's not appropriate, whereas the appellant is contending for that eventuality.
I mean, that may be a slightly simpler. There's potentially three alternatives, which is to provide for it, to rule it out, or to neither rule it out or rule it in, but have a condition which allows the case to be made and considered. There is a sort of, it's not quite black and white.
Okay, let me have a think about whether that needs to come forward separately, but I think the issues that I've heard from the parish council are around that. The capacity issue is a known.
Yeah.
The solution to it permanently and temporarily are the arguments to be made. I think we can have that discussion potentially in conditions. The issue is perhaps on the wider infrastructure issues, but that perhaps is where Mr. Ross picks up on the concerns that have been.
We don't really have a very strong, we think it would be neater dealt with in a conditions obligation section. It's not a very strong view. So if you think there's a way that more aptly deals with the third party concerns, will make the people available. All we ask is it would be helpful a bit of notice so we can make sure the right people here on the right days.
Yes. The other area, just addressing the audience again, is the expression that came through of concern that the District Council hadn't had the opportunity to contribute to the contributions that were being made by the appellants in this case. Now, obviously, when I talk about contributions being made, those are contributions that would be made worthy of appeal to be allowed and the development to achieve planning permission. No prejudice from my point of view in terms of decisions being made or from the council's point of view, but there will be a discussion around the unilateral undertaking that has been submitted by the appellants. And I'm not sure if that's made its way to you, but it is available. And that actually leads me on to a question about the availability of documents electronically. But I would recommend that you, I'm sure the unilateral undertaking as part of the core documents is now on the council's website. Is the draft not on?
No, sir, not yet. Certainly, we can. I have no issue at all, and it probably in the interest of transparency, we can upload the most recent draft so that third parties can.
Sorry, in light of the extent of interested parties' concerns about both the infrastructure generally of Bramley and what is and could be offered by a development, I think it should be there and available, and then it would be easy for the ward councillors and the parish councillors to be able to see. But it would have to be loaded and understood by those reading it that it's currently a draft document and in development.
I completely agree, sir. All I would possibly suggest is, as it's about to be updated in the next 24 hours or so, to avoid confusion, might it be better to hold fire until the updated version? Otherwise, people are going to start commenting on something that's shortly going to be superseded. I don't mind, but it may just be helpful for them.
No, I think that's fair. If it's coming through tomorrow,
yes,
we'll get it uploaded tomorrow. The reason that I think that's okay is that the discussion on it will be Wednesday afternoon, Thursday next week, most likely. So, gents, I'd say look tomorrow for a document that's uploaded that is a draft unilateral undertaking. I have had a copy of it. The council have had a copy of it, and there is discussion ongoing between the council and the appellants. Your own council officers might assist you if you ask the question, but I don't want to drop them in it too early. The document itself should be available tomorrow in its most recent form. And again, a roundtable discussion is exactly what it sounds like. I'm content to have interested parties involved in those sessions. So if you wish to come back to get involved in those sessions, you can. We'll also make sure, and I'm not quite sure how this will happen, but the programme as it develops is available on the council's website too, if that's possible. There won't be a programme till we've had the discussion after lunch, but whatever we get to after lunch, if we can get that loaded, again as a draft, subject to change, anything we want to put on the top in terms of caveats, because with the best will in the world, inquiries do have a life of their own as they develop. But we can usually stay pretty well on target once we've established a programme. Hopefully that helps. The other thing that was in my mind was we are getting a number of documents in, inquiry documents. Is it possible to do live loading of those onto the website?
There's a file, sir, on the website already that has a couple of things in it. I think
Great.
ours inquiry documents before the inquiry opened. But anyway, we can add the documents in it today.
Very good. Thank you. Okay. Let me ask the question. Having set a number of hairs running, tasks to be done, whether parties would appreciate, rather than calling Dr. Hickey to the stand for the first of our witnesses, whether an extended lunch break would allow us to get on top of these matters and come back, deal with them, and then start with Dr. Hickey. Would that help?
Yes, not so much the extended lunch break, although that is never refused, but mostly just because I would prefer, I think, Dr. Hickey too, to just get going, and rather than have to start his evidence in chief and then stop it. I don't think I think my estimate is about right, but I'd rather we didn't kind of just do 20 minutes of him and then have lunch and then carry on afterwards. So I would support the suggestion. It would be sensible to just have the break now and then deal with Dr. Hickey this afternoon.
Okay. Well, we're just approaching 12:30. Just give me a reasonable estimate of what you as advocates feel would be a reasonable break for you to get on top of the matters that are out there. So we can come back. I mean, my gut feeling is saying if we came back at 1:45, have maybe quarter of an hour to just get the programme done, and then we can kick off at 2 with.
That was my distinctive reaction. That was my distinctive reaction. So yes.
Very good. Okay. Ladies and gents, what we're going to do is we're going to set the teams off to go and resolve some of the issues discussed this morning. We're going to give everyone a chance to have a break, grab something to eat. We're going to come back at 1:45. We'll then hopefully just deal with some of those issues of programming and documents and et cetera, and then we'll be having our first witness, which will be Dr. Hickey on landscape at around 2:00 or just before. The offer is there if you wish to stay. I understand that you've had a chance to present your statements. Look on the website for further documents, look on the website for programmes coming up. If there are other sessions you want to come back and get involved in, and we'll try and make sure that the programme remains a live one and response to what happens each day. So hopefully, you can align Thursday with, discussions on unilateral undertakings, or, the Tuesday with discussions on transport. Don't take that yet as the right answer, but the programme will be kept updated to assist. So hopefully that gives you an idea of where we're at and where we're going from here. For everyone else, I look forward to seeing you back here at 1:45. Thank you very much indeed. I'm going to do a quick test. If I switch my mic off, for those who are left in the room, we okay? And around the table, I'm sure we are. It doesn't have any effect on the streaming. That's run by these little things. That's right, isn't it? The streaming is picked up by those. I think we can save the dancing fingers.
Yes.
While we're here, if we have more people, obviously, in the audience, we might have to revert back to microphones. But if everyone's happy, we'll attempt to progress without mics. Life always there's a mantra there somewhere, isn't there? Life is always easy without microphones. We said before the break that we'd have a little look at a couple of things. I'll just remind people of a couple of documents that are floating around that I was looking for copies of. One was the British Standards 7193 2013. That was my hidden document 2. Document 5, which was the authorities, Mr. Sergeant, was floating around as well. But I think apart from that, we are up to date on this document.
So yes, on the authorities, I'll get hard copies overnight for you, if I may.
That's fine. Thank you very much. I've had the housing land supply proof from the council. Yes, from the council. I have to look quickly inside. That's very kind. Thank you very much. I'm not recording these as documents. They're things that I would have had normally. They've just arrived. Why have I written Mr. Dawes evidence? Oh, Mr. Dawes evidence in terms of the programme. Now that makes entire sense to me. And then we were obviously going to have a quick discussion on programme. There was going to be a bit of thinking about how, when, and if Mr. Dawes' element of the settlement pattern commentary was to be included. And the thoughts are?
So I've discussed with Mr. Dawes, and as I indicated before the adjournment, we're happy to do that on Thursday morning.
Excellent. So the programme as provided to me by the appellants this morning, subject to my request to move the closing statement up a little bit, is as close as we're going to get at the moment, do we think?
I mean, I don't know what the appellant's views are, and obviously Mr. Banner knows how long he thinks he'll need cross-examination. From our side of the room, we did wonder whether, I think in short, we think we might get through it all rather more rapidly this week than is on the timetable. And we think there is a possibility we may end up finishing. I think it is probably the best case possibility, and it may be an unlikely one, but I think there is a possibility that we will even finish the heritage evidence on Thursday. And just from the perspective of having said to the third parties that the roundtables would be happening on Tuesday, I think we just wanted to see what others' views were in that respect.
I think that feels quite optimistic, because even my programme, my original programme had a possible roundtable sneaking in on Friday, but I think Mr. Banner's indicated probably 3 hours with Dr. Hickey on heritage, which I think is pretty comprehensively going to deal with all of Thursday, really, or with Mr. Dawes' evidence in the morning, Mr. Burton's, and then Dr. Hickey. I think that's going to take us well into Friday. And we'll have to see how we split that cross-exam if it gets to that. But I think Thursday might be optimistic. I think we should probably commit that we don't go into the roundtable sessions that the interested parties might have a role in before Tuesday, and we'll just find a way of managing our time in terms of getting away on a Friday. I think that's probably a fairer way to do it than mess the programme around too much.
You can see it's very early, even with my most optimistic suggest that's where we might get to. But I think there's an outside chance that we will get through, certainly from my perspective, things quicker than I'd anticipated. So I just wanted to flag that, because I thought the interested parties might come back after lunch. As it happens, they have not.
No.
Anyway.
I think it's a programme that's got a reasonable amount of slack in it, and I do think we do better than it. But I think the benefit will be Mr. Hutton's heritage evidence sliding into this week rather than into next.
Yeah.
But we will keep an eye on it. I think at the moment, if it's agreed, we could put this programme that came from the appellants. Although, could I ask that the closing statements do live to the start of Friday? Because the other point that interested parties I'm finding are increasingly coming along to is to hear the summary of the cases at the end.
Could I reserve the right to barter with you over this time on Friday? I mean, even if we make it 11, the reason I'd say that is it sort of really does depend, from our perspective, on whether we do finish the other evidence on Wednesday. I mean, if we have a lot of Thursday to prepare, I mean, it's an important case for everybody, and if we only have the fag end of Thursday to do the closings, that probably wouldn't do it justice. If we've got 2/3 of Thursday and then overnight, it probably would. So it sort of does turn on that.
Yeah, I mean, the site visit is going to take up much of Thursday, and I'm sure, as much as you enjoy trekking the fields of.
Oh no, we won't. It's more about the conditions. I mean, frankly, if it's just conditions and planning obligation on Thursday, I'll suggest to Mr. Grant that he doesn't come along to that. I'll hold the fort here, and he can start beefing away on the draft. If we both have to be here for much of Thursday to do, say, Mr. Ross's re-examination and end of his cross-examination, they're going to be in difficulty.
Okay.
Just on that point, sir, I obviously don't have the benefit of Mr. Grant's assistance. I don't know where I'll get to, but there might come a point next week at which I am the one that has to barter because I will have to write my closing by myself.
Well, we have some bartering time there. As always, everyone has commitments. Fridays are often a day of commitments. I always try to finish early on Fridays to allow people time to get home. I have a particular commitment on that Friday. And so there will be bartering from lots of points of view. My aim would certainly be not that it should ever bounce over into another week, but I would be amazed if we're not well ahead of the game by that Thursday. We'll have done badly if we're not ahead of the game by that Thursday. That, I think, programme can be put then out on the website, because then the hints that I've made to the councillors can be fulfilled in terms of the likely timings. But let's keep an eye on it. Let's update it when we need to.
So I don't think we have the appellants. And could I just clarify, at the moment we are putting closings in for Friday morning then?
I would like to have them in at Friday morning, please. That's about the only change that I think we've ended up with, having looked at that. Although I don't think there's a round table on infrastructure on Tuesday the 17th. I did sort of hull around a bit, but I think the infrastructure issues are around contributions to support infrastructure in the village, which is the section 106 discussion, or drainage matters, particularly the sewerage in the area, which again we've set for a discussion of conditions. It does mean the condition section might be quite a long one.
Yes.
Yeah. But I don't think there's a need to have it as a round table on infrastructure. Otherwise, we'd be ending up duplicating or kind of setting aside a condition, or we might have a decision on the condition, and it would reduce the time at the end. But I think it's promising more than it's going to deliver a round table on infrastructure if the issues are solely around the section 106 contribution and the drainage issue. But I think the transport matters is an important one to pin for district councillors and parish councillors, which is lunchtime at 2:00 on Tuesday, when I take the infrastructure out, if that makes sense.
Yes.
So if those couple of tweaks can be, I wouldn't change the positions of anything else by removing that infrastructure. One, I don't think it changes, if you like, the overall programme. We just remove it and bounce the closings up, and then that can go to the council to put on the website.
We'll do that now.
Lovely. Thank you very much indeed. Look at my nagging list. I don't think I've got anything else now. Anything else that raised its head over lunchtime before I asked?
So when you got the British, was that one of the documents you were handed?
Yes, I was one. The British Standards was one of them.
Was one of those, you've got it already. Great.
No, sorry, it was one of them, but I haven't got it.
Okay, well, in that case, let me. There you go.
Thank you very much.
Reading.
That was document 2. I noticed it's got a CD number as well, just there we go. Anything else raised its head over lunchtime that we could discuss before I ask Ms. Sargent to introduce Dr. Hickey?
The only thing is that I don't have or the council doesn't have a full set of the inquiry documents,
The core documents.
The inquiry documents that have come in today. We have most of them. I don't have to hand a copy of that British Standard, I don't think, so I can find one. But whilst we do, between us, I think we have a copy of the third party statements. I somewhat unwisely scribbled an initial on them, so they're not, strictly speaking, entirely clean. It's nothing that I wouldn't be happy to put on the website. But if you have a clean set, sir, that we might be able to borrow for an hour scan.
Yes, I've only got document numbers written in pencil at the top, so I can hand those over, and they can be. You can take whichever of them that you wish. There's no other comments. I have a nasty habit of scribbling on things, but I don't remember scribbling on any of them. The openings I sometimes scribble on. There is a tiny scribble on one of the openings. You're okay with the openings, right? Apart from that, the rest of them are fine. Don't read my scribble on that. No, it's a very polite scribble.
Nonsense.
Good. Thank you very much for that. Okay, well, we're bang on time. Dr. Hickey, 2:00, Tuesday. Sergeant.
Thank you, sir. I am going to put my microphone on just because my own voice.
If you're comfortable, absolutely.
And before I introduce Dr. Hickey, so in terms of the documents that you might have to hand, obviously his proof of evidence, Mr. Smith's proof of evidence, evidence versions 2, and then 4 documents, 1.3, which is the LBIA, 6.1, which is the appellate statement of case, 6.6, which is the landscape statement of common ground, and you've just handed it over to us, actually, which isn't very helpful to have mine back, which is the GLBIA extract that came in this morning, or I think Mr. Grant.
Oh, sorry, we'll catch up with it.
Can I just confirm there wasn't a copy of the landscape statement of case on there? I don't know whether somebody's had it, else has had it.
Okay, for the purposes of
a statement of common ground.
Statement of common ground. Sorry.
For the purposes of evidence in chief, Dr. Hickey, I can just use the sentence that I'm interested in. Thank you, sir. So if we pick up your landscape proof of evidence and turn to page 3 of that document, we can see that it tells that you're Dr. David Stewart Hickey, principal consultant of David Hickey Associates and Landscape Consultancy, and the Landscape Institute Registered Landscape Practice. And at 1.3, you tell us you're a specialist in the field of landscape design, landscape design and landscape ecology. You've set out your full qualifications and your track record in Appendix 1. You've got over 30 years experience providing expert landscape advice for a variety of complex projects. In 1995, you were a member of the Landscape Institute's working group that developed India First Edition. You're the author of National Landscape and Visual Impact Assessment Guidelines prepared for the Environment Agency, a leading academic researcher and writer in the field of LBIA and EIA. And we can see at 1.6, you confirm that you visited the site on the 13th of October 2022 and walked around the site in the local area. Can you confirm, as you set out in paragraph 1.2, that all of that is true and accurate?
I do.
And picking up what I anticipate, and perhaps wrongly, but what I anticipate will be put to you in cross-examination in respect of this Libya Swan extract. We can see that it's an extract that shows who the working party members were said to be, and we can see that your name isn't in that list. What's your response to that, please?
My response to that is I was in the initial working group party, which was chaired by Sue Allison, who did a tremendous amount of work on that, and she had to retire from the group because of ill health, and I retired from the from work because I was chief landscape architect for the National Rivers Authority. So it looks as if the working group members at the end got their names in it there. Not a problem with that, but I was on that working group.
Thank you. And before we sort of get into the substance of your evidence, are there any corrections that you need to make to your proof?
There is just on the visual effects on the view, the assessment view E. On that,
which page are we on?
So we're on page 42. E.
E, yeah.
E. That's right. So the direct close views of the fields to the north, it should read to the south of the Brenda Parkway, of course, to the view southwards, not northwards. So I apologise, sir.
Thank you. Anything else in terms of corrections?
No.
Good. So if it's acceptable to you, I'm not proposing to get Dr. Hickey to read out his summary, but I just want to sort of summarise, orally the scope of his evidence and ask him the questions about the appellant's landscape evidence. First of all, a couple of overarching points in relation to methodology. We know, we can see from the core documents that the appellant produced an LVIA that is CD 1.3 dated December 2021, and then we have the environmental statement chapter 6 dated March 22 that deals with landscape and views. Which of the appellant's assessments did you take into account in producing your proof?
I took the second, the environmental statement. Is that the part of the planning documentation? That was the final bit that was submitted as part of the planning process.
Thank you. And then Mr. Smith has now provided additional material in his proof for this inquiry, and this was in his appendices. There's the zone of theoretical visibility work and the photo montages and updated tables and outline his revised assessment in the light of that material. Have you had the opportunity to consider, first of all, that new material in his proof and his appendices?
Yes, I've seen that.
You'll have seen, it's obvious from his proof where he acknowledges this, there are some differences between the conclusions of the environmental statement and the LVIA and the conclusions as he now sets them out in his proof. To what extent, Dr. Hickey, have your conclusions changed in the light of the new material provided in Mr. Smith's proof and appendices?
None whatsoever.
And now, the other overarching point on methodology that we should pick up, if we could take up your proof of evidence, please, and turn to section 4.0, page 21.
21. Yes, I've got that.
And we can see at paragraph 4.1, you say, whilst the general methodology of the appellant's LVIA consultants follows acceptable practice as described in the Glivia 3 and the Associated Landscape Institute clarification statement, I don't accept the premise that only major or major moderate levels of effect are significant is reasonable. I don't want you to read out, obviously, everything that you've said in this section, but can you just summarise for the benefit of those listening who haven't read your evidence?
Yes.
What's the point that you're making here?
The point is that for an environmental statement to decide, does this require an environmental statement, you have to show that there are major or major moderate levels of effect. For it then to be actually significant in environmental statement terms. This is a planning application within a rural setting here. What we've got is that in significant planning terms, it doesn't have to be major or major moderate to actually be significant in planning terms.
Thank you. And to what extent does Libya 3 dictate the threshold, as it were, for a conclusion that something is significant or not significant?
It doesn't do that precisely. There are explanations, but no actual definitions within that. It keeps it relatively vague.
Thank you.
And has the talks about a range from more significant to less significant, rather than being actual precisely major, minor, or whatever, which is a sensible approach.
Thank you. So I want to deal first, just in terms of the overall structure of your evidence in chief, I want to first look at landscape character effects, and then after that come on to do visual effects. So thinking first about the methodology that you've used in your proof to consider landscape as opposed to visual effects, can you confirm for the inquiry, please, what methodology you've adopted in your landscape analysis?
In the landscape analysis, what I did was follow through the methodology as used by the appellants, and went through that stage by stage, and came up with a different answer as part of that, using their definitions, using their criteria, coming up with a different answer at the end of the day. That on my page 30, at the end there, we've got working through all their diagrams and definitions. It actually shows that we've actually got something that's moderate to major effect. And that's one of the things working through with that I thought it was useful to have those, I put dotted lines in this case, but for the viewer to see actually where they do intersect on the diagram, which is one thing that's actually missing from the appellant's work, that you have to work that out yourself, which seems to me not completely transparent, not helpful to the reader. And I've tried to be helpful to the reader and saying this is what, if we're high, medium sensitivity in that case, and medium substantial, we get something that's in the moderate major. So guiding people through to see how I came up with my answer, which is slightly different from the appellant's view of the landscape effects.
Thank you, Dr. Hickey. If we could turn actually on that point to page 21 of your proof of evidence, paragraph 4.6.
I've got that, yes.
Is that the point that you were referring to just now?
Yes, well, I suggest it is rather convoluted in terms of the process, that you have to go that and follow it through and check through on the diagram and move to the next stage and then on to the next stage. It's quite convoluted, but it is in accordance with the Glyphia principles.
And then at 4.7, we can see that you say that using the appellant's methodology, you concluded that the landscape effects are considerably more harmful than suggested by the appellants, Libya Environmental Statement 6.0 and associated appendices. Let's just unpack that kind of headline conclusion a little, if we can, please. Could we look first at your approach to the baseline here? So could we go to page 7 of your proof? Which is where your first reference comes to the 2021 landscape character assessment. And over the next few pages through to page 11, you're dealing with that landscape character assessment. So can you summarise, please, to what extent you consider the site and the surrounding area reflects the character area that's defined in the 2021 LCA?
It's certainly, as we can, reading through that, it's characterised by a patchwork of mixed farmland, woodland, a diversity of other landscapes. And we can see actually that's what we've got on the ground, and except there's two areas that are abutting each other. But what we've got is that there's something there at this sort of level that the landscape character assessment 21, at that level, it's showing that this the site that we have, the large open fields, the existing mature hedgerows and mature trees, and the system of footpaths through that, small woodlands over to the northwest. That's typical of the sort of character of these sort of landscape character areas.
Thank you. Now, I appreciate that I think you haven't got a hard copy to hand, but so I'll just read you that it's a single sentence that I can read to you. If we could take up the landscape section of Common Ground, so this is called document 6.6. And at the end of that document, which is only a short document, 3 pages, so at the end there's a heading that says areas of disagreement between the parties, and the first bullet point under the areas of disagreement is the appellant has concluded that the appeal site is a medium scale and enclosed due to a combination of the gently grading terrain and the surrounding structural vegetation and or buildings. The council disagrees with this conclusion. Why, Dr. Hickey, do you disagree with the statement of the council that the appeal site is medium scale and enclosed?
Inspector, when he goes out on site, we'll see that. And if I just turn to him at the front there, what we've got are actually quite a large scale field. So when you're within that, you do not feel that you're in an enclosed landscape. It's quite wide, and the hedgerows are actually, some of them are tall, some of them are low, some of them you can see into the next field. So what we don't have is the typical landscape that we would normally call enclosed, with high mature hedges all around, or walls or other features that creates an enclosed character. What we've got here is something accepting it's enclosed by mature hedgerows, but it actually isn't necessarily true to call it an enclosed landscape in terms of the landscape that we've got elements here.
Thank you, Dr. Hickey. And then if we can go to page 26 of your proof of evidence, please.
I have that.
And you'll see the heading above your paragraph 6.5 is appellant's misunderstanding of the value of the landscape. And working through essentially paragraph 6.5 to 6.12, you explain why you consider the appellant has misunderstood the value of the landscape. Again, not to read out there verbatim, but in summary, what's your argument in those paragraphs 6.5 through to 6.12?
The argument put forward by the appellants is we've got something that is of local authority value because we have the conservation area to the south, and therefore that will have some influence on some of that. The actual conservation area is actually influenced, and the whole of the site contributes to the conservation area, providing it rural context, and also that we've got the site also contributes to the settings of the historic assets within the area. And the looking across to the my heritage proof, as I mentioned at the end of 6.6, it shows an explanation of those settings, which show the whole of the site is covered by at least one setting of one of the heritage assets. And therefore, suggest that it's just community value on part of the site is an incorrect statement.
Thank you. So moving on from the baseline to your assessment of the landscape character effects, paragraph 2.3 of your proof on page 4, you summarise where you get to in terms of landscape effects, permanent, major, moderate, negative and significant level of change across the whole development site, the higher level of harm along the northeast of the site where the major urban form predominates. Let's look at the reasoning behind that in a little more detail, if you can, please. So the meat of this is paragraph 6.14 on page 28. Which is the beginning of the section where you look at magnitude.
Yes, that's right.
Change.
Yes.
So could you summarise what you're doing there, please?
In terms of that, it's looking at the change, and what we've got is, in this case, I've used the appellant's table A5 on the change, and it's which level of change. What we've got is something at the moment that are large open agricultural fields that will be changed to some form of built development and managed public open space with orchards and skate parks and other features. So to suggest that this locally is a low or a medium would be incorrect. It's a large level of landscape change.
And that's where, can you just go back slightly or proof to page 25, please? Which you should find figure 17. And we can see that the heading to figure 17 says extract from design and access statement illustrating the proposed public green spaces, which will not be pursued by the future generations of open countryside. What leads you to that conclusion and why does it matter, Dr. Hickey?
The important thing is that what we've got is a landscape. We've talked about the landscape character of this area, large open fields enclosed by mature hedges, etc. What we've got here, so we've got agricultural fields. And what we've got here, as you can see in there, suggested they're meadow walks, etc. What they're creating is a country park. And most people don't perceive, the general public do not perceive open countryside. They perceive it to be fields, whether they're arable or pasture, with woodlands, etc. The country park feel with managed benches, paths through that, etc., and meadows. And in the case here, they were talking about community orchards, etc. This is actually not the sort of typical open countryside that people are experiencing currently as they walk around the periphery of this site, which is fairly unique in terms of it's got access on three sides, very good access on three sides. The public footpath along the southern boundary, the western boundary, and the Brenda Park away of regional value along the northern boundary.
Thank you, Dr. Hickey. Moving on to visual effects of the scheme then, if we can, please, and turning to page 32 of your proof. Paragraph 7.1, You say halfway through that, whilst I accept that the appellant's visual impact assessment methodology is acceptable in terms of GLIBIA 3, which allows for a range of acceptable methodologies, I've chosen to use the following visual impact assessment methodology. And this also follows the GLIBIA 3 principles, but so in a more transparent manner. Why, Dr. Hickey, did you consider it appropriate to use a different methodology here to the one used by the appellant?
Because what we have is for the reader following through on the logic of what you've got, to go through all the stages, all the little triangles and everything else. But each one of those takes quite a bit of following through. And again, we don't have the intersections mapped out. So I use a very simple, a traditional process, which is using the assessment significance matrix in terms of this significant sensitivity of the change magnitude there. And this is, I found, much simpler for people to follow through and explain, and gives the same answer at the end of the day, which I have used both approaches, and I found this one a lot simpler in terms of usage and assessment. And a key thing that we are doing as landscape professionals is trying to assist the reader and the decision makers in coming to their conclusions. So understanding which are more visually obtrusive, or which effects are major and which are minor. It's actually part of that process is trying to lead them to that understanding of what those are.
Thank you, Dr. Hickey. And we saw that you referenced GLIBIA 3 in your paragraph 7.1. What's your take on how your methodology, fares when you look at what GLIBIA 3 requires of a methodology?
GLIBIA 3 doesn't require anything of a methodology. It's basically a recipe book. And it describes itself as a recipe book, basically. In other words, it is described, obviously, in other words, but it doesn't prescribe any prescriptive way of doing it. It's all about each site is unique, and each development proposal and the elements within that, the landscape and the visual, it's getting the most appropriate for the landscape professional to choose the most appropriate assessment process that will enable the decision maker to have a good understanding of the assessment process and what the assessment is trying to say.
And then looking across at paragraph 7.3 of your proof, you say the sensitivity of receptors will be dependent upon three key factors: receptor type, distance, and whether the view is direct visibly or is a restricted or glimpse view out across the landscape in front of them. And then in 7.5, we can see again distinctions between direct close views and indirect distant views. And just so that everyone has understood this correctly, what is, in a nutshell, the difference between a direct view and an indirect view?
So direct view is in front of you. Indirect view is either to your one side or the other, simplistically.
Thank you. Turning to page 35 of your brief, please. There's a series of photographs, figures 20 to 29. And where did these originate from?
I took these on site as a set of panoramic photographs. They are intended to give the inspector an indication of that landscape. And of course, the inspector will be viewing that for himself on site.
And then if you could turn to paragraph 7.6 on page 34, please. And it's your figure 19. you can see that you say that this is showing the key locations that you have assessed as being important to assess key points A to I. What was the basis, please, Dr. Hickey, for your selection of these as being the key locations important to assess? Why have you sort of, picked out this series of views as material to your assessment?
Well, they are both included within the views and vistas identified in the neighbourhood plan. And as you walk around, these are the key views, these are the key points, the corners of the field, where you look back, where you move into the next field, when you view across the fields, when you go on along Brenda Park away, when you look back from that, there's the first, I've got two views there, the D across the field there, and then the E further on towards the village itself. So it's the logical, sensible views that are important to the viewers, and the key receptors that we've got, which are walkers, and then I've got view G, which is the back of the houses, which gives if we turn to it on page, my page 27, which gives a view of the sort of view that is seen from the rear of those properties over the hedge.
Sorry, which page number?
Page 39.
39.
Figure 27, view G is taken from the top of the farm access track, which I accept is not a public access track, but it's giving an indication of the sort of landscape view at the rear of those houses, the sort of glimpse views that those will get, to give the inspector an idea of what that currently is.
Thank you, Dr. Hickey. Are there any other points on these series of photographs in terms of what they show to the inspector? Or, I mean, the inspector will suss all this out on site himself, I'm sure, but is there any other points about your rationale for including these that you want to flag? Or?
No, because these are the key ones, both in the existing neighbourhood plan and from actually walking around the site, that as any walker would. These are the key views as you go around.
Thank you. Moving on then to look at what you have to say about the visual effects of this scheme. Paragraph 2.4, summary on page 4, where you say the appellant considers not visual effects decreasing in time, and your conclusion is permanent negative effects ranging from very high to medium high, with one location being medium. And if we can turn then to page 41 of your proof. We can see that we have table 1 there, which is setting out your conclusions, and you've summarised that even more succinctly on page 45, where you have a heading, Summary of Visual Experience Impact Changes. Now, to the extent to which there are points of disagreement between you and Mr. Smith on the level of impact in visual terms, why do you say to the inspector that he should prefer your conclusions over those reached by Mr. Smith?
The difference I think we've got is that Mr. Smith is suggesting actually the 76% retained open spaces will be the same, if not better, than the existing open countryside. What I'm suggesting in my stating in my proof is that the open countryside experience, when we replace that with this managed suburban green parks, country park feel, where it's got hard surfaces, it will have wildlife areas, etc. But it's not the same experience from the viewer's point of view. When they stand there and look over there, as we were walking around, there were people walking the dogs and they were experiencing that. That open countryside experience will be replaced by one that is different and, in my view, is not as good as it's because they've got an open countryside view now. Mr. Smith would argue, I'm sure, that actually what it's been changed to is just as good, if not better. So it's that difference in this managed area that accepting. I mean, having worked for Warwickshire County Council, sir, and designing many country parks over my career there as senior landscape architect. They are not open countryside. They are different. They've got a different feel for the people who use them, and that's quite acceptable. And but in this case, what we've got is we will have the loss of the very nice footpath system all the way around. Really good open countryside experience while you're there. Relatively quite tranquil. You can hear the birds singing. You can walk along there. You can see in the hedgerows. I admit, there still will be blackberries in there, but actually in the hedgerows. But actually, the experience of the large open fields does give a sense of expanse, and actually helps, I think, with that sort of within this zone, with the sort of sense of tranquility as well, that experience of walking around in this location. So to be changed to something that is much more allied to an suburban experience, with, I know we'll have skate parks, and I'm sure they will be very sensitive around the screen. But people will know they're there. It will be not the open countryside that people are used to and enjoy. It's ordinary countryside, yes, but it's quite a good value in terms of the experience that people enjoy at the present. And there will obviously, getting near the house areas, there'll be glimpse views of the housing estates, and so it's a community building. There'll be that, the orchards, and the other sort of domestic paraphernalia, both of the residential areas and of the community areas. In terms of that.
Thank you. And just picking up on a related point, so I'm going back to the statement of common ground again. Dr. Hickey, I know you haven't got this, but it's just the next sentence. So under areas of disagreement between the parties on page 3, the second one says the appellant has concluded that the appeal proposals would result in some landscape visual benefits as a result of habitat creation and large areas of informal recreation. The council disagrees with this conclusion. Dr. Hickey, again, what's the reason for the council's disagreement with that point, please?
Because in terms of the character and the biodiversity, what we've got here are a biodiversity that we would expect with large open fields like that, which accepted are monoculture, but actually monoculture are very good for various birds and other species as part of that, with a large network around the side of them. So in terms of I perceive the actually going back to, as I say, sort of it would be a sort of country park, have a country park feel to it. And in terms of there would be a change in that biodiversity and those habitats, but there won't necessarily be something that people are enjoying any more than what we've got at the moment. And I would suggest that they would be enjoying less because of the large expanses, large open fields, green fields. You're opening your lungs. You can see your footpath goes a long way in front of you. So it's a very enjoyable experience for the receptors.
Dr. Hickey, do you have the appellant's statement of case to hand, called document 6.1?
Yes.
If you, within that document, look at paragraph 2.7, please.
Which statement? Ours.
Yours, yeah.
Ours. 2. Give us a moment.
2.7, I've turned up.
2.17
2.17, sorry,
on
apologies.
page 7. And you will see that it said there, the second sentence, the appellant will demonstrate that both the visual and landscape effects are limited and localised, and no more than could be expected for any edge of the settlement development. To what extent, Dr. Hickey, do you agree that it's accurate to say that the impacts here are no more than could be expected for any edge of the settlement development?
Well, in this situation, what we've got is quite a unique situation because we've got the footpath on 3 sides and we've got the heritage element in terms of that. We've got the conservation area to the south, the Church of St James with the setting of the site is providing the contributing to the rural setting of that. And then we've got Stocks Farm. So we've actually got an area but it's not just any ordinary edge of settlement. It's an edge of settlement at the moment that is contributing to the wider landscape and the heritage as part of this village.
Thank you. And could we then go to paragraph 2.10 of your proof of evidence? On page 5, please. We can see that you've set out there your overall conclusion of the landscape aspect of your evidence. To what extent, Dr. Hickey, has your view changed, having had regard, obviously, since you wrote your proof to the appellant's written evidence?
I still stand by with my assessment and my conclusions.
Dr. Hickey, is there anything else that you'd like to raise by way of evidence in chief, or are you satisfied that we've covered the overview of your evidence?
Not at this point in time. Thank you.
Thank you very much, Dr. Hickey. Thank you, sir. That concludes the evidence in chief on landscape.
Mr. Sergeant, thank you very much indeed. Mr. Banner.
Thank you, sir. Good afternoon, Dr. Hickey.
Good afternoon.
When did you first accept instructions in this matter?
I would have to double check on this. So I visited I accepted instructions on this in late September, early October.
You visited the site after having accepted.
That's right, yes.
This.
Yes, that's right, yes. Yes, I had a good look at the material that was provided online with Mr. Smith's evidence and the ES there. And I looked around Google Street View, etc. And I came to the conclusion that I disagreed with the general conclusions. And I felt I was able to put forward a proof that confirmed my reasoning that the general tenets of the council's reasoning for refusal was likely to be correct in landscape terms.
You'd agree with me, wouldn't you, that it's an important part of the inspector's consideration of this appeal to go and visit the site, form his own judgments, yes?
Absolutely, yes.
But you accept instructions to defend the council's reasons before visiting the site?
Yes, that's right.
And you've visited the site, you tell us in your proof, 1.6 once on Thursday the 13th.
That's right.
And on that single site visit, you had to consider both landscape and heritage at the same time.
That's right, yes.
And I'll ask you about that again in the context of heritage on another day. How long was that site visit for?
It was about 4 hours. And then driving around as well.
Driving around within the 4 hours or
After that, after I was walking around, having a look round, going back, taking some more photos.
Understood. All on that same day?
All on that same day, yes.
And in terms of desktop work, you've not done your own ZTV, have you?
No, that's right. I'm quite happy with Mr. Smith's.
And you've not done any computer-based modelling,
We have.
have you? No. The photographs that you produce go to, for example, we've got a few questions on those, page 35, firstly, and following. You've not produced any sort of photo montages or wirelines. These are photographs of the existing situation on the site, are they?
That's right, yes.
So the extent to which they are or aren't represented, often the inspector can form his own view when he does the site visit.
Absolutely, yes.
I won't ask you about too much about those photos. Now, you also, your landscape proof is replete with aerial photographs. I mean, if one does a sort of flick through, it's the cover page, pages 6, 9, 10, 11, 14 and 34 all have aerial views. Can we agree that these aren't really very much assistance to the inspector in assessing the landscape and visual effects development, because most people aren't going to experience the site from the sky?
I would disagree with that. I think it gives the inspector a very good idea of the sort of landscapes that we are looking at. Both the inspector and the general reader, in terms of that, they may never be able to see it from that particular angle, but it gives them an idea of what the landscape is in the wider context. And the good thing is about here is, for example, on the front, you can see the wider context of this site within the village and further over. So it just gives an idea. And I accept it isn't part of the assessment process, but it assists the reader in being able to understand the landscape.
And the reason, of course, Dr. Hickey, why one has to go up into the sky to assist the inspector, as you put it, to see the site in its wider landscape context, is because when you're on the ground, as most people experience the site will be, the site's rather well contained.
The site is contained within large fields. Yes, I quite accept that, and the inspector will find that on his walk around. Very large fields with relatively low hedgerows, as can be seen by the photograph on the front there.
Need to elevate because the site is well contained.
So that's not what I said, as you.
You said yes, didn't you? That the question I put to you, perhaps if you give a clear answer and then qualify it, then we won't have any misunderstandings again. The reason why you have chosen to put in no fewer than 6 aerial photographs, as you say, to assist this inspector in seeing the site in context, is because you can't do that from the ground because the site is well contained. That's right, is it not?
No, it is not. It's the site is not well contained in that sense. This gives the overall context for you then to actually be able to go back in the field and understand what's over there, the other side of that hedge. And what you can see, because as you can see, for example, in this, so if we look at this field here, we've got a footpath coming up along here. And we can see that, you can see across this. This is a relatively low hedge here. And within that, it doesn't create a sense of enclosure within that landscape. So accepting there is a general sense of enclosure there because it is enclosed by this field. Because of the size of the fields and size of these areas, it's not what we would traditionally call an enclosed landscape.
Doctor, if you give 4-minute answer every questions, then I'm not going to accept criticism. I'm very happy if you do that, but I'm not going to accept criticism going over my timescale. I won't take the hit for that. Can we then take up the landscape statement of common ground? And could you, that is, remind myself of, it is CD 6.6. And we needed a.
Do you have a copy? I'm sorry, because
I do have a copy, but I need my copy. But
I do apologise.
There may be a copy in the core documents.
I think there was.
So that was the one that was missing.
That was on the missing. Aha.
Got the one.
Got it.
No.
Right.
That's the one that I
You
did.
signed it, so I.
Yes, that's right. So I've got an electronic copy.
I mean, that will do.
But I haven't got access.
Right. I see. Okay.
I do apologise, sir.
Fine.
I don't have immediate access to it, but we've got one here. Thank you. Thank you so much, Jim.
I just wanted, I can see if we can put the debate that we're going to have between us into some context so the inspector can see where it's going. We start, if you may, on the first page. We are, of course, agreed that the site is not within a landscape or landscape related designation. It's not a valued landscape for the purpose of the framework. Yes?
That is so.
And I think I heard you describe the site in chief a few moments ago as ordinary countryside. That's what you said.
That is so, yes.
That is so. Ordinary countryside. And over the page, we see at 12, it's agreed that the majority of existing hedgerows and trees, paragraph 12, will be safeguarded and there'll be extensive areas of new species-rich grasslands, new hedgerows and orchards. That's agreed.
Yes.
And we see at 21, 22, it's agreed that landscape receptors assessed in the LVIA and the representative viewpoints are both appropriate.
Yes.
And that must mean as well that they are appropriate in terms of being representative of the implications, to use a neutral word, of the development from public rights of way and from heritage receptors. Yes?
Fine. Yes.
So, because you said in chief before, the site was fairly unique, and I won't take issue with the tautology there, but they're fairly unique in relation to heritage and public rights of way. The receptors and viewpoints are a valid means of testing that, are they not?
Yes. So, I mean, I'll just correct myself. So this site is unique. Therefore, is it not? With 3 sites, I won't repeat myself, but every site is unique.
So the inspector can form his judgment appropriately on the impact in respect of heritage and public rights of way from the receptors, from the viewpoints in the LVIA. That's the point. And we're common ground on that. We're also agreed at Tragedy 3, that applying Glivia 3, it's inevitable all green for residential developments will have at least localised landscape and visual harm. That's obvious and it's not contested, is it?
Absolutely, yes.
And then at 24, it is agreed that the landscape and visual effects of the appeal proposals would be mainly focused upon the appeal site and its immediate locality. That is agreed.
Yes.
So the landscape visual effects mainly focus on this piece of ordinary countryside, not valued landscape and its locality. That is. So the context for all the debate we're going to have is really where within those parameters, where within the range of mainly focused upon this non-valued ordinary countryside and its immediate locality, where within the range of that the effects lie.
I think you've put that very well.
Thank you. Good. But now, if you have got a hard copy, just don't stray too far away from the statement of common ground, because you may need to dip into it from time to time. For now, and I want to ask you a series of questions now in relation to landscape sensitivity and capacity. I appreciate 2 separate concepts, but the questions I ask will bear probably upon both of those things. Okay? And could we firstly take up Mr. Smith's proof and go to start at page 45.
Proof of yes.
So it's 45 of Mr. Smith.
So I've got para 178. Am I in the right document?
Yeah, no, I want to go to the plates actually. Should we?
Fine, yes, plates, fine. Yeah.
Bear with me. you should have a page 45 after 178, a series of plates beginning with Roman numeral 6.
Yes.
Yep. And we see that if we do a glance through them, that there are urban influences on the site. By that, I mean, they're not located on the site, but they are influences upon the character of the site, and indeed visual influences on the site, in the form of the edge of settlement, various built forms and structures and outbuildings one sees, and then the pylons that go through, as shown on plate X, and over the page at plate 12, and so on. Yes?
I think this is a really good example of where I was saying before. They are such large fields coming to the first plates.
That's the question. That wasn't my point, though.
Sorry.
The point, if you could please stick to the answer to the question.
The witness did give a clear answer, which was yes. And
I did say yes, and I'm hoping that yes was there are urban influences.
Yes,
That was
and I was going on to say the urban influences in the relation to a large field.
Yes.
Because they are so small.
Vanna, you know very well my witness is entitled to give you an answer and then to add to it.
If it's on point. If it's on point.
Yeah.
Yes.
Yeah.
If it's relevant.
I'm sure if it's not, the inspector will let Dr. Key know.
We will.
So my point here, this was the fields are so large in space. The actual photos here I mean, if the field was only that wide, I would accept you've got quite a considerable urban influence. But these are only little small dots on a very large field. And in exactly the same way that these pylons marching across this field, it's a huge field. And actually, the field space dominates as opposed to these man-made features coming across.
So, the inspector obviously will judge this when he does his site visit, but you're asking him, in terms of testing the credibility of evidence, you're asking him to bear in mind when he does that your approach is that the pylons and the built form should be seen as small dots. That's your...
Oh, relatively small, yes, in terms of that, yes, because they're such large spaces.
Just write that down, small dots, relatively small dots.
So I don't think I said small dots. Oh, well, I may have said some. I apologise. Not small dots. Small
dots.
Okay, small elements. Small dots. Well, small dots is fine. If you see it from the far side of a field, there will be small size. They're small elements. So I certainly accept that. It's not a problem.
Can we then go to your proof on this same issue? Again, we'll come back to Mr. Smith's evidence on more than one occasion, so don't put it too far away. But go to your proof, page 7, which is something you took the inquiry to in your evidence in chief as well. Do you have that?
I have page 7.
And you there, in the context of the landscape character of the site, refer to the Basingstoke and Dean landscape character assessment, yes?
Yes.
And you purport, as I understand it, on this page to summarise the appropriate aspects of that assessment insofar as they relate to the character of the appeal site.
Yes.
Yes. And at 3.3, you refer to the reference in the character assessment to the landscape having retained a quiet rural character. Yes. These words come from the LCA, don't they?
Yes.
Yes. Let's look at what the LCA actually says. It's at it's at core document 5.3. Right, keep that reference in your proof open. 5.3.
I will have to. Core document
5.3. Volume 5 is, I think, principally at least, the landscape related core document. So it's probably worth, if they're in a lever arch file, taking the whole lot.
We've got 5.3.
Correct. While you're there, take 5.4 as well, because we're probably going to come on to 5.4 due course as well. So if you go within that, page 53. So I don't know if 53 is the same page on the electronic copy, and the golden rules probably won't be. They are the same, aren't they? That's 53 of the pagination in the bottom of the page. And that should be in capital at the top of the page, character area for North Sherburn.
You were quite right. It's not there. Not on the blank page on this page 50.
Okay.
But if you'd like to
We do need it because obviously there's something you refer to.
No.
So I'm entitled to ask you some.
So we're
So it should be a section, capital letters in bold, character area for North Sherburn, which is obviously the part of the LCA you purport to summarise on your page 7, including your 3.3 quiet rural character. And I want to see what this document says.
right.
PDF, it's at 28, according, I think, if I'm looking over Mr. Smith's shoulder.
Sorry, 20.
I don't know why it's 28 on the PDF and 53 on the hard copy.
Double page.
Right, double page. Okay.
Oh, I've got Bramley. Oh, yes, we're there.
Okay.
So I've got Bramley. Yes.
I think you're jumping ahead. This is CD 5.3.
So we're the one before.
Character area North Sherburn, which is the one you refer to in your proof.
Yes.
Sherburn.
Yeah. Fine.
Sorry, I think Dr. Hickey might be in slightly the wrong core document. Are you in the sensitivity assessment?
This is the,
yes.
Yeah, that's the next. That's the document we're going to come on.
We're on. Thank you very much. So I'm supposed to be looking at 5.3.
5.3. Page 53. Well, it's 52 and 53 double page spread. That's why it's only. Yeah, I assume that's why.
Okay, that's fine.
Character, if what you have that, sir. We've got that. Good. And so this is the part of the landscape character assessment, which your page 7 of your proof purports to summarise the extent it's applicable to the appeal site.
Yes,
correct. And we see at page 53 under overall landscape code. You see the box, and you see the photo with the telegraph wires running over, and then it's the last 2 sentences. Do we see about 4 lines? In many areas, the landscape is retained a quiet rural character. Yes.
Yes.
And that's the bit that you're referring to at 3.3, isn't it? Because
that is right.
In many areas, the landscape has retained a quiet rural character with a network of narrow winding roads linking dispersed villages, hamlets, and isolated farmsteads. And that text is exactly what you cut and paste into your proof at 3.3, isn't it?
That is so, yes.
But you stop there, don't you? But the text doesn't stop there, does it?
No, it doesn't. It goes on to talk about an areas that yes.
Do we read what it does say? The bit that's cut out in your. I was going to read it out.
Yes, the quietness of the area is described. However,
fine, Dr. Hickey, I'll ask the question.
Yes, sorry.
The quietness of the area is disrupted, however, in the areas on the A340 corridor, and the rural character affected near the larger settlements of ... Bramley.
Yes.
So actually, the reference that you've put into your proof, quiet rural character, etc., is qualified, isn't it, in the text that you've omitted, qualified by the reference to rural character being affected near the larger settlements of Bramley. That's right, isn't it?
That is so, because professionally, I think they've got it wrong.
Why do you say that?
In terms of this area here, they're talking about, and this is a character area, so they're talking about large scale, and I accept that. But in terms of picking out the key elements of that, they're talking about the landscape has retained a quiet rural character, a quiet rural character, and the inspector will find that on site, that actually, as you're walking around, the key thing, it's a quiet rural character. It's not really disruptive, it's not disrupted by quietness. Yes, you can probably hear the cars on the road, but they don't adversely affect your enjoyment of that the walks around the site. So that is why I accept I missed out that final one, because I didn't think it applied here in this location.
But wouldn't it have been better to, rather than omit the qualification in the council's own, it's the evidence base of the council, isn't it, for their emerging local plan, only a year old, 2021, by HDA, an expert consultancy, yes? And wouldn't it have been better to, rather than just cut out the bit you disagreed with, let the inspector know about it and explain why you disagreed with it? Wouldn't that have been a bit less misleading?
I don't think it's misleading at all. I'm just picking out the area, the character elements of this that are appropriate for this site. And what you'll find is the overall landscape character of this area. What I'm actually saying is picking out those that are appropriate for this site. And not all of those are. And it talks about minor valleys and extensive woodlands. Well, I'm afraid we haven't got minor valleys and extensive woodlands in this part of the character area. So I apologise, sir. I wasn't trying to mislead you at all. I was just picking out the elements in the character assessment of the Sherborne character area for the key ones that applied, that I felt applied.
And in this last sentence that you omitted, you said a moment ago, well, the quietness of the appeal side isn't affected by the A340, but there's 2 points in that last sentence, aren't there? Because as you see the comma there,
yes,
the quietness is disrupted by the A340 corridor, comma, and the rural character affected near the larger settlements of including Branley. So the effect of the rural character by the settlement's edge isn't an A340 corridor point. It's a separate point to do with urban edge, isn't it?
No, you're absolutely right. And the inspector will find in this particular location that actually it's a very quiet area. You may have the occasional honking car.
That's my question, Frank. My point was the rural character effect is a separate point. The A340 character. What they're saying is it's an effect due to it being on the settlement edge of a large.
And that's absolutely, and that's what I was saying. You're absolutely right there. And I'm saying on the edge here, the actual character there in terms of quietness is not particularly reduced. We haven't got a very noisy road. The road actually, when you walk along the street, is actually dipped down, and the houses are up on either side. So, in terms of there is obviously a traffic issue in terms of this, but actually the inspector will find when he walks around the site that this is not a site that's particularly unduly adversely affected in terms of noise.
Not sure you're
being edge of settlement in this location. There will obviously be other areas of Bramley that are adversely affected.
Dr. Key, it may be I'm not expressing my questions very well. I'm not asking about the first half of that sentence. I'm asking about the second half.
And I was sorry
about the first half.
No. I'm talking about the second half.
Yes, we are overlapping to referring back to the roads, but I think the point that Mr. Banner has asked you is that there are 2 influences on the noise effects with the LCA, not just edge of settlement, but the A40. They're separate in there.
I accept that. Sorry, sir. What I was doing was suggesting that there are roads within the settlement edge.
Yes. Also.
That will also. I certainly wasn't talking about the A340 corridor. So I certainly was focusing on the second clause within that sentence and saying yes, in terms of these larger settlements will have some noise, but the noise actually coming from those houses and the other bits.
Again, I think we're cross purpose, if you don't mind, Doctor, because I'm not making a noise point. The point, what I'm suggesting, and I'm a little bit unclear as to whether you agree with my characterisation of the report, is that when there's reference to the rural character being affected near the larger settlements of, amongst other things, Bramley, it's not just talking in terms of road noise, it's talking about the rural character being affected by being on the edge of a larger settlement. By the built, let me finish the question first, don't mind. By the built form, by the pylons, by the points that I took.
Absolutely.
That's it. It's consistent.
Yeah, I would accept that, yes. Yeah.
And so do you agree or disagree with the observation that this landscape character area is near the edge of Bramley, the rural character is affected by the things we've referred to?
Yes.
So it is relevant.
Yes.
So you did admit a relevant factor in your proof there, 3.3, didn't you?
Well, I was suggesting the road. Yes, in terms of that, yes. Okay. I'm quite happy to admit that element there.
Thank you. All right, and
elsewhere.
Sorry,
but I've dealt with it elsewhere in terms of the character.
Where have you dealt with this sentence?
Have you
dealt with the fact that the council's own expert, that it's commissioned for an independent review for the purpose of its virgin local plan, has made observations about the effect on the rural character near the edge of Bramley, which you've cut out from your quote from the relevant part on your page 7. Where have you referred to that sentence in HDA?
No, I didn't say that. It was the concept of the rural character on the edge of there being affected by the settlement. It's dealt with elsewhere within the landscape effects.
Well, the point you developed, but you don't grapple with the fact, and it's the point, Dr. Hickey, you don't grapple with the fact that an important part of the evidence base, namely HDA's report for the council, barely a year old, for the purpose of its emerging plan, you don't agree with, and you haven't grappled with that.
Well, there are lots of things I don't agree with in this world, but if I went through it every line, every page, what I'm saying is the key thing that they were saying that they are stating in their assessment is about the quiet rural character. And I think, sir, you'll find that as you go out there, that's the key thing that strikes you. It's a relatively quiet rural character.
Very well. Let's go. Can we now then go to,
which is my point,
the CD 5.4, which is the other. This is also HDA.
Yeah.
Because they've done effectively two reports, 5.3, which is the character assessment, and then 5.4, which is the landscape sensitivity study, and they sort of go hand in hand.
Yes.
And their documents, again, this is also a document produced for the council barely a year ago. Yes.
Yes.
For the purposes of the emerging local plan.
Yes.
So it's not some historic, it's a document the council presumably still relies upon because it's still preparing that plan, yes?
That is so.
So could we go within this document that the council still relies upon to page 30? Again, almost certainly a different page number electronically, but the reference should be BRAM 001. And if you could let me know when you've got it, please, Dr. Hickey.
I have that page, yes.
Thank you. And let's just get our bearings. BRAM 001 is shown in blue on the top left, isn't it?
Yes.
And that is essentially the appeal site as a whole, yes?
Yes, it is.
And we must recall that this study is looking at the site as a whole, whereas the appeal scheme, of course, is for the development for housing of 24% of that site, yes?
Yes.
So in terms of looking, insofar as this study is relevant, it's a sort of more than worst case scenario because it's looking at the susceptibility of the whole site to development of the whole. See what I mean? I haven't expressed that very well, but I assume you expect to get the point. Now, let's just have a look at various sort of points. So we. General visibility, well, everything generally tends to be, broadly speaking, middle of the road in terms of scores, doesn't it? I mean, at a very high level, if you look through the scores, broadly speaking, middle of the road, which is consistent with your reference to it being ordinary countryside. And in terms of, you talked earlier about one of the, in fact, not just quite unique, you upgraded that to actually unique, the public rights of way around the site. But in terms of general visibility, which obviously has regard to folks, so 3 out of 5. So middle of the road, actually, not unique, yes?
That was their view.
Yes, that was their view. So HDA's view is having regard to public rights of way, middle of the road, and we look at it's an open to view along sections of, in particular, Brenda Parker Way. Occasional views through gaps in boundary vegetation from dwellings, generally well contained from the wider landscape to the west. ... Then scenic quality. Scenic quality reduced by views of man-made structures. Do you see that?
I see that, yes.
The view of
yes.
HJ in the context of this document and relies upon for its local plan. And then we see on the next page, 31, this is also in the same context, under tranquility, reduced by filtered views of man-made structures.
Yes.
And then indeed, just so I jumped ahead, but if we go to, again, rurality, glimpse of settlement edge, pylons and rooftops, etc. And again, it's intactness, reference to the field pattern, such as some hedgerows partially degraded.
Yes.
And then I think there's one more, landscape susceptibility is somewhere. I think it's, yeah, if we go a couple of pages further, and I won't read every point out because the inspector will read what it is in due course and we'll refer to it in closing, but reference again to tranquility being affected, more references to pylons, etc. Yes?
Yes. Can I just point out to the inspector that we will see on page 31 that there are a number of theirs that aren't middle of the road, that are higher than middle of the road. For intactness, we've got a 4. For settlement, pattern and identity, which is important, we've got a 4. And historic value, we've got a 4 there. So I accept that for a lot, there are 3 middle of the road, but there are some that are higher and some that are lower.
And pulling all of that together, the overall conclusion is medium, isn't it? At the bottom of 31, medium landscape sensitivity, yes?
Yes.
Yes, and medium, we can understand, well, if we go earlier to page 7 of this document, we're told what medium means. So if you could just turn that up. I think it's page 7. Sorry, it's page 8. I do apologise. Page 8, medium sensitivities in bold text on page 8, if you can let me know when you've got that.
Yes, I have.
And that tells us, again, expert view HDA in the context of this barely 1-year-old document, part of the plan evidence base, the council still relies upon it. Medium may be able to accommodate the relevant type of development in limited situations without significant character change or adverse effects. Yes?
Yes.
Now,
and they come to that, as we can see over the page, sir, on 2.9. What they do is they just add up the numbers. And those numbers, they add them all up. And so it's a summation of all those little pockets that we've been looking at on page 30, 31. And they come to a number, which they've got 30. So yes, accepting. But that's how they come to get to that figure. And I would question that process. I would say that is not necessarily actually the best process in the world if we actually think about it, because we're actually not giving any weight to any of those. Do they suggest they give any weight? No, they don't.
Have you asked them? Have you tried to contact?
It just doesn't.
No, Ms. Dr. Hickey, could you ask Ms. Dr. Hickey? I'm afraid the way this works is I ask questions and you answer them. And the question I'd like to ask you now is: have you contacted HDA and sought to ask them about their process and methodology that you now criticise? Have you done that? Have you done that?
Because on 2.9 it very clearly says the scores for each element are then summed to give an overall guide to the sensitivity of the site. So I don't need to ask them the question, have you weighted them? Because they've said they've summed it.
So just to be clear, so your view is if the council were to continue to prepare its plan in reliance on this, its plan wouldn't be sound, wouldn't be based on a sound evidence base. Is that your view?
It's my view. In some locations, it may not be correct.
Do you think is the council able to prepare a sound development plan based upon this evidence base? Yes or no?
This is a good starter, but I haven't.
Answer the question.
I have. So, yes, I would expect that.
Yes, it was sound.
But I haven't been through every page to actually check.
So yes, it would be sound. Yes, it would be sound. Or
yes, he would be sound on the basis of this.
Now, I say HDA may be able to accommodate. Can we then look at your proof? 6.12. 6.12 second line, no ability to accommodate. So you're at odds, aren't you? Sorry, so that's page 27, paragraph 6.12 second line. You judge that the open.
That's right, yes.
So there's a difference of expert opinion, is there not, between you and HJ?
Absolutely, yes.
Yes. You don't, again, this other HJ, you don't grapple with this either, do you? I mean, you've already looked at, you didn't grapple with the other HJ report. You don't grapple with.
There are lots of reports. I could grapple with many of this.
Answer questions. Do you or do you not grapple with this report?
No, I do not.
Don't. Thank you.
Because we've got many reports, and it is my professional opinion that that this particular landscape has no ability to accommodate proposed urban form.
I mean, you say you've got many reports, but let's be fair, Dr. Hickey. This isn't just any old report. This is a less than 1 year old report prepared for your client, this inquiry, the council, which it still relies upon and is building the evidence base for its future local plan based upon this document. It's not just any old report, is it?
No.
It's something that should be given real weight in the context of this debate, should it not?
Yes, in retrospect, I could have explained to the inspector in quite some detail how the fallacies of how they came to their conclusion and how I disagreed with it. But I thought it was quite much simpler to explain to the inspector that I felt within this, my professional opinion, within this landscape type and sensitivity, it cannot accommodate the proposed urban form that we're suggesting.
You say there's many reports, and there's no reports like other independent reports of the nature of this one that actually support your analysis, are there? We refer
very often there aren't.
Yes, but you mean so it would be fair to, because in any case, the inspector has to look at a basket. Let me ask the question first. Basket of different perspectives, but it would be fair for the inspector to work on basis. You're the outrider here, aren't you? There's Mr. Smith and HDA who are roughly in the same place, and you're asking the inspector to do something a bit different. You're the outrider, are you not?
Yes, I am the outrider, and I've explained to the inspector the issues related to their methodology is that all they've done is summed all these features that we looked at on page 30 and 31, and with no weighting. And I would suggest that is a good starting point. And when you're doing a huge exercise like they've done, that is probably a good way to do it. But when you come down to the detail to sift through that, I would suggest we need to take a more nuanced look at this.
One more question, then I've probably reached a good point, actually. And that is, could you take up Mr. Smith's paragraph 168?
168.
168. Yeah, of course. So that should be page 43. It's factually correct, isn't it, what Mr. Smith states here, that the site at Station Road, Oakley, which is in the core, the decision is in the core documents. You'll be seen references to it, sir, which was allowed not just on the basis of a tilted balance, actually, was accordance with kind of landscape policies. That was categorised in the HDA CD 5.4 as the same category, medium sensitivity, wasn't it? That's factually right.
Yes, it was. That's factually right. Now we understand the issues here that two sites like this can actually come to the same medium sensitivity, because all they're doing is adding up the numbers.
Right. Thank you. I say this. That if I start another section, we're going for quite a while, so this is probably a good moment to break. So,
thank you very much. I suggest an adjournment, Dr. Hickey, if you can keep yourself isolated during the period. Adjournment till 2:30.
Excellent.
We'll come then. Mr. Brown, just very quick check for me. Latest version I had was 2.5 hours, which would have brought us in just about on time. Well, how do you feel?
Well, I think started Tuesday, we're 40 minutes in. It's going to be at least, I mean, it's taking a bit of time.
Yeah.
I can't mean any criticism, it takes what it takes, but I'm on page 2 of 9. Some of those pages I could jump over, that's where I am. So
that's fine. Okay, thank you. Back at 2:30.
Thank you. Yes. Not very much else than media, but it's basically trying to do that anyway. Yeah, that's the chief point.
Last session of the first day, partway through Dr. Hickey's cross-examination. Mr. Banner.
Thank you, sir. I'm very sorry. We have to go back into that CD 5.4 because it's been pointed out there's one paragraph I ought to put to you. So it's CD 5.4, the HDA sensitivity study, page 7, paragraph 2.10. And if you again, Dr. Hickey, let me know when you've got that. Because you were saying before we had our break that you were criticising the sort of the numbers game approach, if I can summarise it, that of HDA as you characterised it. But let's just have a look at paragraph 2.10. It doesn't stop at the numbers, does it? They say this: the overall guide score is then reviewed to consider whether a specific or overriding aspect of sensitivity be under or overweighted in the consolidation of the profile into a single overall rating. If necessary, ratings can then be adjusted up or down to reflect individual situations, ensuring that professional judgment is the final arbiter in the assessment process rather than relying solely on an arithmetic system. So pausing there, Dr. Hickey, it's not right, is it, to say that HGA apply a purely numbers-based approach to this, is it?
Yes.
So yes.
Yes, it is.
Yes, it's not right.
Okay. If we read that sentence, I was very surprised when we read it. The overall guide is therefore reviewed to consider whether a specific or overriding aspect has been under or overweighted. Well, they haven't weighted anything, sir. What have they weighted?
Well,
they haven't weighted anything. What they're saying is if it doesn't look about right, well, we'll go back and have a look at the figures. And I can understand that approach. Okay, that's a valid approach to say there's gross error. They're not saying, they're saying there has been under or overweighted. There is no weighting. They have got no weighting system.
But you've not sought to check with them what they meant by under or overweighted?
Well, because they actually say they sum up all the figures.
So, let's be very clear, Dr. Hickey. Are you suggesting to this public inquiry that when HGA say in this public document as part of the local plan process, Council as one, professional judgment is the final arbiter in the process? Are you saying they're lying?
No, I'm saying they actually have mistakenly written that sentence incorrectly. I would suggest that doesn't describe what they have done in this study, because they have very clearly in the paragraph 4 said we sum all of the figures.
And you really feel professionally able to say that to the inspector without even having bothered to check with HGA what they actually
haven't checked, because you've actually pointed it out. This, and I was reading that, but it actually clearly says that. I'm very surprised that they say that. There is no evidence at all, because they've actually said something that completely contradicts what they say in 2.9. I mean, we can go into this some detail, sir, or we can just accept that it's...
Well, I'm not sure we can go into some detail. There's two.
No, I don't think we can. I don't think we can. We agree.
What your answers to it?
I think you have, sir. I think they've actually got it wrong.
Now, landscape value is the next theme of our discussion. And as we know, we will have that discussion in the context of what we've already seen, which is we know it's not a valued landscape, no development plan landscape related designations. But a further point is this: is there's no emerging local plan proposal to change the current position and to designate the site for its landscape value, is there?
I am not aware of that.
Right. And if that is right, then it follows, doesn't it, that the site wasn't considered by and still is not considered by the local authority to have sufficient local authority level landscape value to justify designation. That's right, isn't it?
My understanding is...
Yes, that's right.
So that is correct. My understanding is that a lot of local authorities now are not putting landscape designation. So it is, and the actual... I'll just leave it at that. So.
I've actually been asked, Joe, because we saw, I don't have it to hand now, but we saw from one of the people spoke this morning. I think was documents handed in where the council actually asked to designate the land as local green space, hasn't it? It's been asked and it's declined. Correct?
I don't know about that at all.
Now, your proof at page 27, 6.6 and following, as I understand your analysis on this page, is broadly speaking as follows: that the whole site should be given local authority level value because it is in the heritage setting of the conservation area and certain listed buildings. Is that a fair statement?
No, that is not.
Right. Okay. So when I see at 6.6, you say it would be appropriate to conclude the whole of the site has local authority value because it includes both the conservation area setting and the heritage setting listed buildings. Is that
that is so, yes.
Okay, well, that's what I thought I was summarising.
Yes. Can I just explain that what I'm, in terms of local authority value, this is something Mr. Smith raised that was relevant to the area along the border, the conservation area. And he's saying in his proof that part of that has local authority value and then community value. And what I'm saying is no, if you accept that part of it has local authority value because of the settings of the church, conservation area, contribution of the site to the rural context of the conservation area, if you, following on from Mr. Smith's argument, it isn't community value, it is local authority value.
I'll come to what Mr. Smith says in a moment, but just looking at what you say on this page, as I read 6.6 in its terms, it is the fact that the site includes, your words, both conservation area heritage setting and listed building heritage setting. It is that fact which you consider means that the site should be ascribed local authority value. Is that correct?
Yes, following on from Mr. Smith's assessment that the southern portion of the site has local authority value in his words, I was saying he's actually incorrect in saying it's just that area because the local authority designations of conservation area and national designations of settings for listed buildings apply to the whole of the area. So if you're following on from that logic that we've got a strip at the bottom that we can define as local what it has as he's defined as local authority value, the rest being community value, I'm suggesting no. And what we've got is something that is completely local authority value if you are taking that approach.
So I think it follows from that, and from what you say at 6.6, you repeated as 6.8 and 6.11. But your position is that the fact that the appeal site is within these heritage settings, as you see them, is not just relevant to landscape value, one of the basket of considerations, it's determinative. It is a factor which means that the site must be accorded local authority value. Is that right?
No.
Right. Okay, so where do you deal with the other relevant factors? Show me where in the proof.
It's so the value of the sites. So I'll just have to spend 10 minutes. The value in terms of that, what we've got is the on 6.7 on the loss of the rural character. I accept that is related to, but in this section, in terms of the value, I would accept, I ascribe that to that landscape value to be a majority in relation to that heritage element.
It's all heritage. 6.7 is heritage. 6.8 is heritage.
I would accept that, yes.
I mean, let's cut to the chase. Keep that open. Can you go to CD 5.2, which is the Landscape Institute guidance on ascribing landscape value?
Okay.
CD 5.2, it's local guidance note, CDGN 221. I assume you're familiar with this.
Yes.
I just know. And can we go within it, please, to page, or to sections, the number of pages, but begins page 7, table 1, range of factors that can be considered when identifying landscape value. If you let me know when you've got that table before you.
I think we're talking, are we, yeah, the table starts on.
That's on page 7, a third of the way down, table.
Page 7, sorry.
Page 7.
I'm going to have to battle with you here, Mr. Banner, battle on with you because the document's unavailable off
Oh dear.
site. So electronically, I can't grasp it.
I wonder whether there might be a.
So that's, sorry, I've been having timeout messages on the council website, and
I think it's because I'm sitting on
completely.
You see, after we log in, it probably is one. Sometimes I'm very happy to kind of just do it if you like.
I think that I can send to access.
Give me a second and I'll see if it'll.
May even, but find it on Google. But I think it probably is one, so you ought to have before you ask these questions.
Oh, the heady days of having 9 boxes.
Oh, some of us, it's an ongoing thing.
Yeah, you're right. It must be a timeout thing because it never does load. I mean,
Like you said, so do you have table 1 on page 7? On the PDF, I think it might be 11.
yep.
You got that, Dr. Hickey?
Yes, I do. Yeah.
I mean, let's just do it. I feel like if you don't mind, a sort of page turn, because what this table does, doesn't it, is it sets out the Landscape Institute's guidance on the what I would call that the basket of factors that you could have regard to, and just doing a quick page which is natural heritage, cultural heritage, landscape condition, associations, distinctiveness, recreational, perceptual, scenic, perceptual, wildness, tranquility, and functional. And that's the basket of factors.
Yes.
And would you agree with me that the proper approach, as commended by the Landscape Institute, is to make an in and around judgment based upon all of those factors?
That is so, yes.
And thank you. And it's wrong, isn't it, therefore, to focus on one in isolation and to the exclusion of the others?
Not necessarily if that's the only one and that's relevant. But what I'm not suggesting is that this is a site with landscape value in MPPF terms.
Right. Well, quite. So if we then go, please, to the Mr. Smith's appendices, and it's Appendix D, D1. I think that's on the collection page. It's 30. Page 30 of his appendices.
Yes.
And that is, when I got it, a application, is it not, of the TGN?
Yes.
It's in that table.
Yes, it is.
As regards, so he does the very exercise that we've agreed in the round analysis, the basket of considerations, and including but not limited to cultural heritage, and the end product of that is that it's not a valued landscape, and the value is set out at the bottom. The community value overall, conservation of the south being of local value. Yes,
that is correct, and this clearly explains. And this is where he actually defines it not necessarily of being landscape value, it of being local authority value. He gives them these two names: community value and local authority value. And what I'm saying is the local authority value he ascribes because of the conservation area to the south should be extended to the whole of the site, because there are other settings within that he unfortunately just missed. And I'm just suggesting. So therefore, if he's starting to call the bottom of the area local authority value, why is he not calling the whole of the area local authority value?
So, unfortunately, you don't get to ask the questions.
So I'm saying he's not.
Would you agree this with me, Dickie, that the tabular analysis set out at table B1 is a reasonable and legitimate application of table 1 of TGN 221?
With the exception of cultural heritage, yes.
But it's taken into account. That's the point. And I thought we'd agree it's taken into account cultural heritage. If you don't,
yes.
Please, if you could, let me ask my questions. It's taken into account. And what it's done is taken into account in the round with all the other factors to reach an overall judgment. That's right.
I agree with you in principle, but he misses out the settings of the other heritage assets.
He doesn't include. Well, hang on, you've got to be very careful here.
Finds includes grade 1 listed church, St James. Well, that's great, but what about? So I have included in my thinking there, sir, of the
Yeah, I understand.
the farms.
There is a difference, isn't there, between a conservation area and its setting?
Yes.
And in fact, under the statute, the legislation, unlike in relation to listed buildings, we have to have regard to the distinction between a conservation area and a setting, don't we?
Yes.
Yes. And what Mr. Smith has done is treat the conservation area and its setting. It's not like he's included some of the setting in one category and some of it not. The distinction has been drawn between conservation area and outside the conservation.
Yes, he has done that.
There's nothing illegitimate. You're saying that's that is something
Yes.
that TGN precludes.
No, absolutely not. Whoops, sorry. Oh dear.
So just be very clear about that. That's not, you've lost.
Apologies about that. Not me.
No, that's all right. Just take a moment.
Done that.
Well, we got any clocks? I do.
I've even seen a member of the Supreme Court doing it with a hearing.
Oh dear.
Very good company.
The hygienic wise, I'll get some.
No, you can just interrupt it, but probably not.
Yes, that does. So yes. So I agree. What he's put down is perfectly okay.
Okay, thank you.
What he has missed out are the heritage settings of the surrounding heritage assets. So I think
Let's be clear. There's nothing in the TGN, is there, that says a heritage setting has to be given local authority value, is there? There's nothing that requires that.
Absolutely.
Sorry, absolutely. You agree. Good. So therefore, there's nothing in his analysis which is in breach of TGN 201.
Yes, he has missed out the stating that there are historic settings within this table. He should have put them in. He may well have discounted them, which are what I would suggest would be incorrect, but he has missed them out in terms of cultural heritage.
Okay. I didn't know, actually, it's my note. Oh, right, okay. Mr. Smith, I didn't realise that, actually. Apparently, Mr. Smith wrote TGN.
The foils.
Ah.
Yes.
Yes, I didn't realise that. Well, there we go. So Mr. Smith actually wrote this. So what you're saying is that the co-author of this guide, this document, has misapplied it?
Yes.
Right. Very well. Okay. I think we'll hear from him on that. Okay.
So could we just take a minute to allow Dr.
It's all right, Mr. Banner. I think was taking a minute.
Yes,
What were you thinking about where your next question was coming from?
I'm probably not for the same reasons, but hourglass was in my head.
I do apologise.
No, it's absolutely fine.
Thanks so much. Yeah, that's right.
Kind of him to give a moment.
Sorry, yes. For different motivations. But I mean, ultimately, this debate on value only goes so far, because even if it were of local authority value, as a whole, as you suggest, it's still not a value landscape. Yeah, absolutely. Yeah. So it's a debate that doesn't have a huge amount of consequence, really, does it?
Not a huge amount in terms of it's not a value, but it is of some, as Mr. Smith has introduced the concept of, quite understandably, at the bottom of his assessment there, in summary, the value of the application side is therefore of community value with conservation area being local authority of value. I'm accepting that, yes, but what I'm suggesting is it's not just the conservation area, it's the area of the settings, which actually, in conservation terms and MPPF terms, have even more value. So the conservation at the local authority is wider than just suggested by Mr. Smith.
It just boils down to, he should have mentioned, as you're suggesting it, he should have mentioned it in a heritage setting, but should still have come to the conclusion that it wasn't.
He may well have come to that conclusion. I'm quite happy with him to come to that conclusion. I would disagree with that conclusion.
Could you just tell me this, how, in your own words, how does one get to a local authority level value without being a value landscape? I struggle with that one myself, but
so do I. Yeah, well, yeah. In terms of this, I perceive that there are a number of features, and I think what we've got are a lot of ordinariness. I will accept that.
Yeah.
And that is important in terms of ordinary landscape. And we've got these features that in terms of heritage are important. But all in all, we haven't got something that is a value landscape in the wider sense.
Thank you. I've got some questions on landscape-related policy. Should I ask you those or Mr. Dawes then?
I think in terms of if it's policy, Mr. Dawes will be dealing with that. Thank you very much.
I will do that. Let me put. I think we can put. We let the put TGN aside. Landscape assessment now. Could you take up Glivia, if you don't mind, and go within it, please, to 5.34 on page 86.
Five,
534 on page predicting and describing landscape effects. So we're now looking at the landscape assessment. We'll come to visual assessment in due course.
Right, I'll just take a second to read.
Oh, please do refresh your memory. And the aspect of this passage that I'm keen to just explore with you is the first bullet. We're told that the first step is to identify the components of the landscape that are likely to be affected by the scheme, often referred to as landscape receptors,
yes,
such as overall character and key characteristics and individual elements or features, specific aesthetic or perceptual aspects. And that's good practice, not just best practice, that's good practice, isn't it, as set forth.
This is one of the approaches that you may take.
Yes. Just tell me, where in your proof do you carry out that first step exercise?
As I say, this is one of the approaches that you can take. I'm taking an approach which is following, picking up on the Mr. Smith.
I mean, if you don't carry out the exercise, that's fine. You say you're entitled to. I may disagree, but do you or don't you carry out that exercise?
Didn't carry out that exercise in detail.
Or in detail or at all?
At all. Well, I apologise. So I'm rereading that sentence. Yes, I did it. I reviewed them and then decided it was not appropriate to take this approach.
Of course, we know that it's agreed that the assessment in the stage of common ground that Mr. Smith's choice of landscape receptors, selection of them, is appropriate. We saw that before, don't we?
Yes.
Nothing wrong with that approach with what he's done.
No, absolutely, yes.
And we go.
Oh,
sorry, I didn't interrupt you. Please do.
Apology. So that's why I followed his lead.
Yeah.
I felt was perfectly okay. So I didn't go through the steps of identifying them separately. Just quick review showed that he was going in the right direction.
And
sorry.
And then just building on the reference in the first bullet to individual elements or features, just go forward, if you wouldn't mind, to the next double page, so 88 and 90. Sorry, 88 and 89 of Livia. 540, susceptibility to change. Okay, it's the paragraph that splits between 88 and 89.
Right, so yes.
And susceptible to change means the ability of the landscape receptor, whether it be the overall character or an individual element and or feature, to accommodate the proposed development. And without undue consequence for the maintenance of the baseline situation, etc. So what that's suggesting, isn't it, is one looks at the that character of the site as a whole, but also then does, and this is my words, but a part by part, element by element analysis. That's a valid approach, isn't it? You look at the individual landscape components of the site.
That would be a valid approach, yes.
And there is no, you call it part by part or element by element analysis in your approach. You look at the site as a whole.
Absolutely, yes, that's right, yes.
Thank you.
So as I've said before, delivery is not prescriptive.
Yeah. Now, I mean, for example, it's not prescriptive. It's got to mean something, hasn't it? I mean, it's there for a reason.
It's there to give you a recipe of ideas of how to take it forward.
I mean, for example, take one approach where we can say, well, look, we know that the hedgerows and trees are being almost entirely conserved and being augmented with further native planting. One legitimate approach on the part by part, and I say, well, that element of the site, that part of the site, that element of the site's character has a lower susceptibility to appeal proposals. That's a legitimate approach, is on the part by part approach.
If you take apart the elements, what I'm saying is you look at the whole, which are fields, the character that we're assessing are an open countryside landscape that is large fields with that are divided up by hedgerows. So to actually pick out hedgerows and assess those individually, I would suggest is not a particularly good approach.
Consistent with this, isn't it? It's consistent.
If you wish to take it, and that's why I'm saying somebody taking that, fine, you could do that.
Just answer that question because I think it could be quite important. Is adapt element by element approach and say, well, hedgerows and trees, conserved and enhanced, and look at it as elements. That is consistent with Glivia, isn't it? In principle, do you agree? I'd like to know where the inconsistency.
Yeah, well, I'm just reading 540 there, and it talks about the overall character that you're assessing.
Or, well, don't pick words, or individual elements and features. So yes, say that's legitimate under this.
Yes, that's right. And absolutely, you're right in that. And so for different projects that you're assessing, different things will apply. And what I'm suggesting in this, to actually say, well, we'll only assess the hedges, and now we'll only assess the open fields, and now we'll only assess the pond, is one way of doing it. But I would suggest that if you actually look at that overview and how those interrelate, you get a much better answer.
What about doing both? What about doing both? That's doing both. That's Glivia compliant, isn't it?
If you try both, yes.
And you don't. So you don't do both, do you? Because you don't do the element by element approach, do you?
No, I don't. No. Absolutely. No, because I don't think it's appropriate. The fact that it may be Glivia compliant, as we say, suggested that it is appropriate for some places. I'm suggesting it is not appropriate for this, and that what you need to do is take a holistic view of a holistic assessment of the landscape that you've got in front of you.
But there's a danger then in nuances if you do that broad brush approach, as opposed to looking both overall, because we don't accept them. Mr. Smith doesn't look at overall approach, and he'll explain that in his evidence. But to also then do that element by element approach, consistency with those passages we've looked at, that is capable of being a more nuanced approach, isn't it, than the look at the site as a whole, don't you?
It could well be, but it's highly unlikely to be, I would suggest. I'm suggesting it may well be misleading in terms of the overall holistic effects, that for you to actually assess a hedge in relation without actually thinking about the fields either side or the ditches, if you're only identifying those individually, you may well be misled in your assessment.
But on your approach, the broad brush, let's just look at the development as a whole and the site as a whole. You don't really get any distinction, do you, between the effects on landscape character, for example, of the parts of the site where the houses are going to go and the parts of the site where other things are going to go? You don't get any distinctions, do you, like that?
What I'm
answer the question, then give your qualification. You don't have those nuances or distinctions, do you? If you just look at the.
That is correct.
Thank you.
Because actually, I perceive whether you've got built form or you've got country park or you've got orchards or you've got skate parks, it's the same development change.
Right. So, I mean, let's be serious here. You're seriously suggesting, are you, that the effect on landscape character of the 76% open space is identical to the effect of landscape character where the houses are? Is that seriously your position?
No, I would accept that.
Right. Okay. So you accept that there are, therefore, different consequences for landscape character and disparate aspects of development. And if you do accept that, which I just said, doesn't it therefore follow that it is a sensible approach to do that element by element analysis?
By development.
Element by element.
Yes, but not by hedgerow or field. That's the wrong way. I accept if you want to come at it from a development type and look at each development type. That's a perfectly rational way to approach this, but I don't think that's been done.
So, I mean, if HDA are correct in their 2021 landscape assessments, sensitive assessments, etc., that the eastern part of the site is visually influenced by the settlement edge and the pylons. If they are correct, I know you disagree with them, then wouldn't it follow that that part of the site, that element of the site, is less susceptible to built development than the rest of the site? That would follow, would it not?
Not necessarily, because looking at the whole thing holistically, actually, you can see what contribution is this landscape making to the wider element. And what we've got, we've already picked up and discussed in detail, in some detail, the fact that the site contributes to the conservation area, the settlement pattern, and the some heritage assets. So it actually contributes those to actually say, oh well, in the settlement here, we could put some development. The actual loss would be less. Isn't necessarily so.
Hiding things, though, Dr. Hickey, because we're talking about we're not talking about necessarily the effect of development here. We're talking about the baseline, the character of the baseline. So that's not a lie two different things.
That's right. Absolutely agreed with you there. So, but it's that edge. The fact there's nothing there on the edge is important.
I mean, let's put it this. I mean, are you saying? And again, if you give us a yes or no answer, and then say whatever you want to after that. But are you saying that the landscape character of the whole site is the same throughout?
No, I would accept.
Okay. So let's just pull this. So landscape character, not the same throughout. The landscape effects of the development, not same throughout. I think we've both read both those things. And yet you still seem to be resisting the element by element analysis approach. I'm struggling with that myself, to be honest. Can you enlighten us?
Yes, sorry, I do apologise. I thought you meant the elements were the fields that we were assessing, the hedgerows, etc., as opposed to the zones. Now, I would accept on the zones,
yeah,
but I would not accept hedgerows on that, because one's your baseline and one's what you're doing to it.
So where, because I don't think you do in your evidence, you do any sort of zonal analysis.
No, that's right. And what I've done is looked at this holistic landscape, which I accept has a different character on one and susceptibility there. I'm looking at that whole and actually saying, what's the assessment of this change? Because the whole of that contributes in a number of ways, as we said, in terms of settlement, there's heritage elements, there's the recreational value of that, which not in MPPF terms.
I think it must follow from what we've just agreed, that if you accept that actually on reflection, given the landscape character varies throughout the site, given the landscape effects vary throughout the development, a zonal analysis would have been helpful, and that your kind of holistic approach is a little bit nuanced. It's lacking in nuance.
I would agree with you. It lacks in nuance, but what I think it's quite comfortably does is picks up the bigger picture, which I think some of the nuanced if you actually look at them individually, you miss the bigger picture.
You could always do both, can't you?
You could do.
Okay, thank you. I think we've taken that part of our discussion as far as we probably can. Just give me a moment. I'm just going to see if there's some things that I can skip over and like. Just give me a moment, sir, because I don't want to duplicate. I don't need to do all that. Okay. So 620. 620 on page 29.
Of
Mr. Sorry, forgive me of your proof. Yes, I do apologise.
Sorry about
your proof. No, it's a very fair question.
On page, sorry,
page 29, paragraph 620.
620.
Yeah, and I think I'm right in saying that this is the only part of your proof that really refers to landscape change beyond the site boundaries. And I just would like your help, please, if you could explain to us where is the landscape change beyond the site boundary. I could then ask Mr. Smith for his evidence on that, but we're a little bit at a loss as to where you mean when you refer to landscape change beyond the site boundaries.
Yes. Right. In terms of this, so there is going to be localised change within the site per se. But in exactly the same way, we can actually reverse it from what we were talking about before, where we were saying this is a field that has urban influences because there are bits over the hedge. So what I'm suggesting is, in exactly the same, reversing that logic, is that the site itself will have an influence over there. Obviously, clearly not over miles and miles, perhaps a few hundred yards. We've got the street that's related currently, the residential elements along the street that are related currently to a rural context to the rear. I think you.
Right.
I suppose I could, without being glib, say it's a localised.
Yeah, I'll take that. And the photo montages are reasonably good. We'll come on to those. A reasonably good means of testing those.
I would accept that, yes.
Thank you. The open space. Can we firstly go to Mr. Smith's proof? Paragraph 94, page 24. Paragraph 94, page 24.
So that's in the proof, not the appendices.
Correct. The main proof.
That was 24.
Page 24, paragraph 94.
Yeah.
Again, if you let me know when you've got those.
Yes, I've got that.
There's no dispute. The figures are correct. So site area 21.4 hectares. 16.29 is open space over 3/4 of the site. That's right.
Those are the figures put forward, and I don't dispute.
And he said, we'll come on to the landscape character of it in a moment. But in terms of amount, Mr. Smith says, in my experience, this is an exceptional provision for public open space. Many schemes seek just to meet or just exceed Fields and Trusts open space standards. Here, that would generate a 1.79 hectare figure. If field proposals are over that by 900%. Is all of that, you're happy to accept that?
I'm happy to accept those facts.
Thank you. Now, at the reserve matters stage, the local authority can, of course, scrutinise and decide upon the finer details of the public open space landscaping, can't they?
Yes, they can.
Including on the character of that open space landscaping, yes?
Yes, they can.
And now, keeping Mr. Smith's evidence open, going to your 621.
Can I just clarify that? I do apologise. Clarify. Of course, From my perspective, in terms of the assessment, it would show that the actual best thing that we can do is to actually retain open fields in agriculture rather than having public open space in terms of it. So
I understand that's your case.
Yeah.
I'm testing that now. 6.21,
page
of your page 29.
My page 29.
Your page 29, 6.21. You make a point here, which is a theme of your analysis, and you developed it earlier. 3 lines at the bottom, you describe the open spaces, suburban green open spaces. That's a term you use that term to move manage, manicure. They all mean the same thing, really, aren't they? That it's a suburban green open space as you see it.
Well, yes, as the people will very much perceive it as that with stone footpaths or even grass footpaths cut through. They used to signage, bins, dog walkers. They're always wanting their bins and benches and other things.
Do they?
Sorry?
I mean, the people walk their dogs at the moment, don't they? On the public rights of way?
Yes, they do.
Yeah. Okay.
So, but I mean, there's a significant larger area that you will agree in terms of paths, etc. Available. But yes,
because the terms of the sound bites we had in chief were managed benches, known meadows, paths, suburban experience. That's the these are all representative.
I would have said country park experience. Yes. Yeah.
Country park, but of suburban quality.
Not necessarily. Well, I would have said country park experience of there. And yes, that has suburban green spaces. They soon become suburban green spaces, because it's so much cheaper for a management. The inspector will be.
Okay, well, that's a different point. So soon becomes. So do you accept? We'll look at some of the evidence in a moment. Do you accept that it could start off in the character of a country park, in a more rural character, and your concern is more about what may happen thereafter? Is it maintained?
No, good point. I suggest that country park is not acceptable in this location. This would be a negative connotation, negative change, because we've got some lovely walks around there with lovely views across wide open fields with the hedgerows.
Well, let's just break that down if we can. I mean, in chief, you started off saying it wouldn't, and I wrote these down, it wouldn't be the same experience, it would be different. But we must just stop there and say it is wrong, isn't it, to equate change in itself as necessarily harmful. That would
absolutely, yes.
So it's not, whether it's not the same experience, different, isn't really the point. Is it deleterious compared to what is there but now, correct?
That is correct, and I would agree that it is deleterious.
I think we're at one on that one. Now, could you then take up, please, Mr. Smith?
Sorry.
Yeah, I think Mr. Banner's point was you were at one with the fact that change
necessarily
actually the sequence of wording ended up with you agreeing that it was deleterious.
So. No, sorry. No,
we're helping you out.
Yes, thank you.
Yes, we understand. I apologise.
Today we're probably slipping our language, but yes, but the point is we need to be looking for something.
Absolutely, yeah.
Something other than change.
Yes, yeah.
So then if we look at Mr. Smith's page 26, I mean, he provides some images as illustrations, page 3, 4, and 5.
Yes.
And these are real, these are not attractive images created on a CGI. These are actually real places, aren't they? Real photos of real places.
I understand they are.
And there's nothing to stop the local authority at the reserve matters stage insisting on something that looks like this. I won't use an adjective. I was going to say informal, but I won't use an adjective. There's nothing stopping them creating something that is of a character like this.
That is so.
Thank you. Have you ever come across such natural rural open spaces on a settlement edge, such as are shown here?
Yes, I've designed a number.
So we can agree that creating such spaces are not only something that the local authority can require, but they can be achieved, as a matter of fact.
They can be achieved, but they're a different experience from the open countryside experience that we
know difference isn't enough. And I mean, they're not, are they? I mean, if we look at these, let's say for plate 4, meadow with the Lakeshead Fertility,
yes.
Oxford.
A lovely bit dandelions, yes.
That site actually. Now, these are not things that can be sensibly described as manicured or managed.
Yes. Certainly as a landscape architect, they can. Yes, you can manicure these, you manage these, and you have to manage them very effectively. Otherwise, they will disappear. They will be the plants. These have to be mown at a specific time of year or grazed at a specific time of year.
So, I mean,
and without that, they won't return. You will lose this within 12 months.
Understood. But you were I took you to use the word managed in your evidence, not saying it will need to be managed in order to be maintained in a nice way, but there's something wrong about management that they have. So,
I'm saying yes, because you'll have to have mowers on here, which is completely different. It will be soon become
to tractors.
Mowned. They will mown however they wish to manage.
What's that in that? I mean, these are not fields currently.
Gang mowers is a bit different.
These are not fields currently that are completely left wild and unmanaged, are they?
No, they've got tractors going up and down, which is part of the agricultural experience, and people enjoy seeing that.
They're not. This isn't the snake. The meadow here. This is Hinkley Meadows. That's not something that can sensibly be described as having a character that's suburban, is it? Would you say that's suburban plate 4?
Within that particular context, I agree. It's not suburban, but it's not open countryside, is it?
But it's the natural habitat for the area, isn't it? You can create. The point is, it is possible to require and create something, let me finish, which isn't suburban in character and which represents the natural habitat for the area. That's right. It's possible, isn't it?
No.
No, it's not. Why not?
No, because what you've done here, actually, this is man managing this particular field in a particular way where you have to.
That's farming with fertilizer that kills all the wildlife.
But it isn't the natural habitats here.
Always farming.
Natural habitats for here would be if you stopped, you have the scrub come in, you have the willow, birch, and it would turn eventually, as an environmental scientist, you'll know it would turn eventually probably to something like oak ash woodland.
There was it. What's going to happen at baseline is farmers continue to fertilise the heck out of the field. Won't be any meaningful wildlife there.
I don't think that's.
It's not, the baseline is not a natural habitat.
No, I'm not suggesting that. What we're suggesting is that it's an open countryside.
But how is, for example, the Oxford plate here, how is that a deleterious change in character?
Because we're losing the experience of the open rural countryside.
That's just change. That's just a different way of saying there's going to be change, isn't there?
No.
Nice.
Because the baseline there was open countryside with large fields with hedgerows. We've got something different now.
Yeah, well, exactly. But difference is, I mean, let's say if
it's a change. Okay, it's a change.
If we're agreed that change or different enough, if we ask ourselves this, putting aside what was there before, because we know change isn't of itself the issue, we say we just look at these plates and we ask ourselves, what's wrong with that? Articulate, please, in a landscape character, what's wrong with what we see on page 26 of Mr. Smith's evidence? What's wrong with that from a landscape character point of view, please?
Well, we've got previously a large open fields. So that's what the person is experiencing as they're wandering around the edges. The fact that you do have to go around the edges, and this is managed, as you would say, a managed agricultural space in terms of that experience, that countryside experience of actually being in the open countryside and not necessarily being able to run across these meadows of Snake's Head.
Again, not actually answer the question, because I said, let's put aside the reference to change. Let's just look at the outcome. And imagine we are in 20, whatever it is, I won't give the date because we give the wrong one, but 20 something in a few years' time, we go and revisit the appeal site and it looks like something like this, but with appropriate native planting. What's wrong with that? What are we going to say is harmful about our experience of landscape?
We lost
It's not going to change. Keep referring to change.
No.
What's wrong with the actual present day experience of that in 3 years' time or 4 years' time, whatever it is? What would be harmful about that experience in landscape character terms?
Well, without me saying, we're saying it's a change from what it is at the moment, which what I'm saying is open countryside. What we've got here is a managed landscape to retain these fertility.
Basically, one managed landscape for another.
Yes,
managed by farmers to landscape managed in this.
Absolutely, yes, that's right.
There's a change in the kind of management.
And the features within that landscape and how people experience that landscape.
Okay. Well, I think if we debate it too much more, I think we're going to labour the point. I think our dividing lines are clear. Visual effect. Now, you very helpfully provide a table on page 41 of your proof. Well, let's say page 41, it continues for a while after that. What you do, as I understand it, is obviously you refer to the viewpoints, you use certain numbering, some of them correspond to the various viewpoints of Mr. Smith, and we'll look at those in a moment, where they are, who the receptor is or are, current position, what the change will be, and then what the magnitude, sensitivity and significance of the change. Now, just looking at the change, first of all, before we come to magnitude, sensitivity, when we look at the various changes, there's various themes, if we do, again, a page turn through. One of those themes that crops up time and again is open countryside replaced by managed suburban green park, etc. Yes?
Absolutely.
And that's the point we just discussed, isn't it? That's basically the visual aspect of the same point we discussed in the landscape character. So I'm not going to go back over what we discussed. That's the same issues we've just debated, yes?
Yes.
Another pervading theme, which comes up, I think, on pretty much everyone, is tranquility perception reduced, yes?
Yes.
Help me with this. I'm struggling myself to understand how tranquility is a visual impact as opposed to something that bears on landscape character. Can you help us with that?
Yes, certainly. I'm
not saying it's not relevant because obviously
no.
It seems a bit odd.
One of the key things is we're talking about viewing experience. And as you can imagine, sir, if you imagine looking at a view, I'm looking out to sea. For example, if I was on the coast, I was looking out to sea, so I've got a view of that. But that viewpoint, if you've actually got, for example, a fish rendering factory beneath you, the smell of that will adversely affect your view. So what you've got is, at any point in time, the viewing experience will be related to all your sensory experiences. So in terms of noise, sound, smell, sight, wind, taste, the salt, etc. They all actually contribute to that viewing experience, which is not just visual, because our brain is not just taking in visual. So it's a visual effect, a visual experience. In exactly the same way that if we think about food, we say food. If we eat food, we need to smell it. And we need to taste. It's not just how you taste, it's also how it smells, the other feelings, other senses come into that. So what I'm saying is very simply there, tranquility is an important element of that viewing. It's how that viewer starts off and is experiencing that viewpoint. And what we've got is walking around here, these big, large open fields. You've got strolling around, they're walking the dog, the skylarks are singing, and they've got the in terms of, there's a relative tranquility there, and lots of other senses as well as part of that.
Right. Okay, I'm struggling a little bit, I must just say, to understand how what can have a visual impact from smell. But without getting into the detail of that, just help me with this. How specifically do you say in a visual way, there is an effect from a tranquility related effect? What is it in terms, what's the effect on visuals?
Yes.
You refer to it being reduced. I suppose my question is how in a visual.
Absolutely. Yeah. Very simply, in terms of tranquility, large open spaces like these fields give the feeling internally of tranquility. So what I'm saying is, when you reduce those spaces, actually that tranquility, and you've got other elements within that, a skate park, benches, other things, they're reducing the visual there's physically the noise.
So I see. So it's all sort of the same point, differently expressed, as you're putting the development on the appeal site, you're putting houses on what's currently a field. It's basically that it's that same point.
Yes, yeah, that's right. So yes. So in terms of what we've got is a change in tranquility with that, because we've got building the houses and visually, when you've got those built forms and other forms, different colours, jarring, etc. So you don't get that same tranquility.
Understood. But I mean, we've agreed in the statement of common ground, landscape common ground, paragraph 23, it's inevitable all greenfield residential developments result in at least localised landscape and visual harm. Plainly, that's going to be a feature of pretty much any greenfield development. Is you're going to see things and people where currently you don't see so many things and people, right?
But so.
Yeah. And frankly, we're going to have to square up to that if we want to address the housing crisis in Basingstoke and Dean. We're going to have to square up to that somewhere. Yep.
Somewhere, yes.
Yeah. Okay. And pretty much in terms of description, we'll come on to the magnitude sensitive significance bit in a moment, but as we kind of do page turn through the various description, open countryside experience replaced by the development, etc. The description of the change is pretty much something that, on your analysis, would apply to any sort of edge of settlement greenfield development. You're replacing a field or more than one field with development, and there are consequences.
That is so.
Thank you.
And the magnitude on the view and on the receptor and their experiences may well change, may well alter dependent on the different viewpoints.
Now, there's one specific point I want to deal with you. Then I'm going to sort of just dig a little deeper into some of the judgments on significance, etc. View F, page 43. Could you also get out CD 2.3, the reasons for refusal? Because you make a point about the landscape consequences of the access.
Yes.
I just want to explore that with you.
Sorry, CD
2.3, the reason, fugitive reasons for you, I should have called today.
I probably haven't got that, so I'll have to.
Could you? I think there probably might be amongst the documents, one of those ones you haven't borrowed from the core documents already, so borrow away. 2.3. And hopefully, in the right number, is that the so it's not actually formally a decision notice because this is not a termination appeal, but it should be a letter purporting to setting out the purported reason for refusal, 11th of October 22.
That's so, yes.
And the landscape related one is the first, isn't it? Because 2 is listed buildings, 3 is conservation area, and 4, 5, and 6 are what I call miscellanies.
Yes.
Looking at what now? We here say it's the development by virtue of its scale of development and location on the periphery of the village. So the things that are said to generate an adverse effect on landscape that leads to that reason for refusal, the scale of development and its location. Yeah.
Yes.
The reason to reference is that to the access, and the access being objectionable in its own right from a landscape and visual perspective, is there?
Yes, because of its location at the edge of the village. Currently, you have a house there, so with fields behind.
Right.
So when you put an access in there, you can then see into the access. There's going to be visibility displays, etc. You're going to be able to see that what was.
Okay.
Am I?
So you're not suggesting that the access is in the wrong. If the principle of development is acceptable, the choice of access point is the wrong place.
I'm not suggesting that, no.
Right, okay, thank you. You can put the reason for refusal away then. Now, I just want to dig deep. Let me rephrase that. Dig a little deeper with some of your judgments on significance. I'm not going to do it for everyone because we'll be here till Friday, but I'm going to just pick a few to test your approach to ascribing magnitude, sensitivity, and significance, if I may. And can we start with viewpoint I, which is on your page 44, it's actually the last one. And we're going to need Mr. Smith's evidence as well, just because, forgive me, we're not far off the end now. So it's viewpoint I, and that's the footpath on the southern boundary of the panoramic view looking north, west, east, and that is, be my good man on this. So that is SLR viewpoint 10, is it not?
It may well be, but I haven't got it. I apologise, I haven't got it in front of me. We were trying to get a copy.
Take your time because we will need it.
Are you taking the reference out of Mr. Smith's appendix?
Yes, sir. So they're the.
Actually, give me the appendix.
Where the appendix at the.
I apologise, sir. My copy doesn't have the drawings in the appendices. It stops at the appendices and stops at page 54 onwards is missing out of my copy. I do apologise.
No, that's fine.
We've had a difficulty in that the appendices came in a separate document to the ZTV and the photo montages. And I did ask for the appendices to be printed, but that was a different document to the one we actually need.
So what we'll do, Jeremy, are you happy to load that version rather than making use mine? Sure. So for the time back, Mr. Smith will lend you his, and then he and I will work from my copy.
Okay, well, thanks so much.
You've got them okay, sir, haven't you? Yes, sir.
I have, yes. Thank you.
So, so first, what I want to do is sort of match up your table to hit to the.
Yes.
Sorry.
So if you don't.
That's it. Yeah. Yeah. So viewpoint 10. There's two photographs because you're looking one way or the other way, effectively, as I understand it. So it's a sort of tried. So let's start actually with the one that doesn't show anything. So do you see? You're not having it.
I'm on this. So that is number
10. But there's.
So
Yeah.
Eye test.
It is
extremely small.
Yes,
I've actually had to break out my glasses, which is very disappointing.
I'm looking at viewpoint 10 existing.
Yes.
Type 3 for the. No, that's not nothing to do with this. Which one are we looking at? So
it's viewpoint 10, but there are two viewpoint 10s because they're standing at the same point, effectively looking in different ways.
Understood. And
so the first is we're only going to look at the comparison between existing and year 15 because we're both agreed. It's like 028 because we agreed that 15 is the good year 15 is.
I wonder if Mr. Smith could come round here and make sure we got the right. I'm looking at the right one. Thank you very much.
Yeah, because I got two viewpoint 10s. One of them has got a telegraph pole in them.
Yes, that's right.
That's right. So the one before
the telegraph pole.
One before the telegraph pole. Year 15. Thank you, sir. That's actually a very helpful reference. And as I understand it, they're the same viewpoint. It's just one's looking one way with your feet, same, then you turn around looking the other way. That's I understand this.
The first one here.
Yep.
Now,
no, that's year 1 you've got there. So this is year 15. So you should be that's the left view there, and that's the right view there. See?
Left. Yeah, got it. Understood.
Yeah, fine. Those are the existing.
Yeah, fine. Okay, thanks on that.
I need to repeat that exercise in a couple of minutes. I think we do 3 viewpoints in total, so not 3.
I've got the gist of it there. Yes.
Thank you. Now, you say, just keeping the viewpoint back to you say that is high magnitude, high sensitivity, leading to a high significance. Yes.
Yes, that's right.
And if we look at your assessment grid, so keep a finger in page 44. We'll go back to a moment, but go to your page 33. That is your visual assessment significance matrix.
Yes.
And where I got to was that high, in terms of significance, was the second highest possible level of effect.
Yep.
Out of, in terms of significance, there's 1, 2, 3, 4, 5, 6, 7. I think it's 9 in total. Is it? One includes none. Is that right? In terms of the number of points on the scale.
Looks like that. Yes.
So it's the second highest possible. So then, just testing that, you stand by that judgment that the effect from this viewpoint is the second highest possible level of visual effect.
Yes.
So sort of literally one rung down from sticking a nuclear power station on the site.
We never said that, did we?
Well, that would be the highest. It's considered with nowhere higher to go.
Yes.
It's presumably the highest level. So,
Yes.
so let's sort of judge then. I mean, there's two viewpoints. Judge, is this really one rung down from Sizewell B? And so this is viewpoint 10, year 15. And then over the page, year 15, looking the other way.
Yep.
Again, yes, that's the first. So if we just take up, again, just judging this, Glivia, 6.39.
639.
Page 115.
Sorry, 115?
115. Just in terms of things you have to bear in mind when thinking through comparison. There's no dispute, is that the photo montages are accurate.
I will accept that.
So we've got to look at the scale of the change in the view with respect to loss or addition of features in the view, change in its composition, etc. Degree of contrast or integration of any new features in the landscape, second bullet. Nature of the view in terms of the amount of time over which it's been, etc. Whether they be full, partial, or glimpses. And just kind of reflecting on what we see in these agreed to be accurate photo montages. Do you stand by your analysis that what we see here is the second highest possible level of significance, one rung down from the very worst conceivable outcome?
Yes, because what we've got here is the loss of the open countryside. So what we're moving to in terms of the here, what we've got is something that isn't open rural countryside, that is just a country park, which, well, if we look at the top one, we've got a nice informal path along the edge, excepting that the one below, we've got some, so I'm looking at the one which is facing it into with the footpath on it, facing it in towards the village with the pole on it, sir. So we've got those features there, but on the one below, we've got something that's very country parkish. We can see new houses there, changing the view. So what I'm saying is that is a quite major change. Well, a major change in what from open countryside to something that is.
Remember, we're not talking about landscape character. We're talking about visual impact.
That's right. Yes. What
seriously stand by that what one sees here, having regard to the extent of built form, the ability of the council to require mitigation, materials in the path that could be hogging, whatever it could be. Seriously say that is one run down from, say, the Sellafield, Sizewell B paradigm, the worst possible. Really?
Well,
I mean, if that's your
agreed. Within that context, I would accept it. It isn't a Sellafield B or anything like that. Yes, no. But within this, in terms of the change of this, and that's what we're talking about, the visual change from the top one to the bottom one. Have we got a problem there? Have we got a quite major problem there? The answer is yes.
Yeah, but I mean, a bit more nuanced that. I mean, just testing your approach. I mean, what your on your analysis, what we see here, and I say I won't label because ultimately the inspector's going to form his own view.
Yes.
But I mean, are you actually seriously asking the inspector to, in terms of judging, kind of a sense check, if you like, a sense check of whether you've over-egged it, that what we see here is not just some harm, but the second rung on the 9-point scale of
Yes, absolutely, because if we're looking over there currently, we can see that there is countryside. There is a field over there. We know on both of these, and we can see there's a field. But if we look on this one, we can see there's a housing estate there. Now, okay, it may not be Sizewell B, but it's a housing estate, and we can see it from there after 15.
On your approach, we might as well put houses all over that field. It'd only be one run worse, 1 point worse, wouldn't we? We might have done the whole field, double the number of homes, and we'd only be 1 point worse on your scale. That doesn't seem, as a sort of sense check, it doesn't quite seem right, does it, Dr. Hickey, that we could develop over that whole field with houses. We can put a tower, the shard of glass there, and only be 1 point worse. It doesn't quite feel right, that, Dr. Hickey, does it?
Oh, yes, it does, actually, because what you've got, it isn't a straight line, is it? What you've got is, in terms of development, that built development and that form, once you've got it in there, which is currently an open field, and then changing to built form in there with all the domestic paraphernalia in terms of that viewpoint there, it's changing quite drastically. So it's not, I will accept Sizewell B, but it's a housing estate.
Right. Okay, let's just do, I might even just do one more, because it may be that we're going sort of, you restate your case and I restate mine, but let's just take at least one more. It's viewpoint, Jeremy, you might just need to go and help. Viewpoint 4, and your D. D is page 42.
It's all there.
So,
One's one way.
that's right.
One's the other. Yeah, fine. Yeah, that's fine. Yeah.
These are actually too hard fun. So it's 4-4-3, isn't it? Sequence. Sorry, let's say sorry. Thank you. Let's do. Do you know what? Let's do 6, because I've lost my. Not 4 left.
So
I took 4 actually. I think Pastor taken it out last night, and I've that for Jimson Evans. We'll just look at it.
yes, so the one that we were looking at was, quite rightly,
And again, just,
up 4
yeah.
was medium, wasn't it?
Well, no, because I thought
Magnitude medium, isn't it?
Lord D, significant. Talk about significance. The significance over its medium magnitude, high sensitivity.
High sensitivity because it's public people.
And then medium high is significant.
That's right, yeah. So medium.
Yeah. And again,
medium.
If you make comments, but try and let me ask the question.
Yes, sure.
Sort of freewheel.
Apologise.
And on page 33, again, your matrix, medium high significance is the 3rd highest rung in your.
Yes, that's right. Yeah.
So again, just as a sort of sense test, really, of your analysis, just to kind of see what you're asking the inspector to conclude, is when we compare existing and proposed year 15 viewpoint 4 as a sense test, the inspector, you're asking him to conclude that difference is the 3rd highest possible level of significance one could conceive.
Because as we've how we get to that 3rd level is because that the value of the receptor is a walker, and their high significance, their high value in terms of that. So we've got something that's the view itself in terms of the magnitude of change is medium. Sensitivity of that viewer, because they are a recreational worker, is high. So we get medium high. So that's how we logically get to that.
I understand your asking. Just okay, so testing. So because ultimately what we're seeing, just to check we're looking at the right thing. So the 50 viewpoint. What we're looking at is a the path, the open space. I say I won't use I won't use a loaded adjective, but the open space. Form our own view as to how we would each describe it. Each of us in this room, the open space and the additional planting. That's what we're looking at, isn't it?
That's right. Yes.
And what your analysis is, if you're right, is that the visual impact of that compared to existing is 2 notches down from developing the entire site with a quarry or
no, the magnitude of that was medium, wasn't it?
Oh, the significance. I asked the question based on significance.
Oh, right. But it depends on, as you're probably aware, it depends on your sensitivity of the viewer, and the viewer in this particular case.
I know it does, which means you've overread the sensitivity of the viewer.
Therefore, if you had if you've got high sensitivity there, that's going to bring some high sensitivity. It's going to bring it up higher, is it not?
Yeah. But you've still got to have a medium magnitude of change, haven't you?
That's right.
And that's a medium magnitude.
Yes. Yeah. Yes, because what we've got at the moment is open countryside. They are enjoying. They won't be enjoying open countryside.
It goes back. And I do suggest to you, Dr. Hickey, you are, however much it's dressed up, there's a change point. It was open countryside, it's now something different. Not that it's a deleterious, it's you keep coming back to and say you're making, as your experience witness, you're doing your best to dress it up, but it's actually your real objection when stripped down to its essentials is there's a change from countryside.
Yes, that's right.
Yeah. Thank you.
And that in terms of the planning process, it's what I'm saying is that's an adverse change, and that valued in this particular case would be medium high in terms of that for recreational walkers who are high grade sensitivity. In this location, changing it to that to they'll be able to see people walking across here. I mean, it's a completely different view from open countryside.
A change from countryside, which we agree to be ordinary, your words.
Yes, that's right.
Not valued. And in circumstances where there's a need to develop on some countryside in order to meet housing needs, yes?
My role is to actually assess the landscape assessment change and the value of that change and the significance of that change, and to provide the decision makers with the information to actually make those sort of decisions. It's not my role to say, well, I've got to have it somewhere, I must choose here.
Understand. I think probably everything else we deal with in submissions or through Mr. Smith. I'm conscious of the time, so I think I'll probably
time takes.
So you feel you there think that we've missed that we could test. I think we've probably dealt with this as fortunately as we can. Thank you, Nicky.
Thank you very much.
Thank you, Mr. Banner. Let me just have a quick look and see whether there's anything I wanted to pick up. No, the couple of questions I had, actually, you spent some time talking about in terms of local authority or community value. And a few questions were around the reference to the local authority's evidence base, which we dealt with in detail. Ms. Sargent, let me come to you and see if you've got any re-examination for Dr. Hickey.
I don't. I have one point. It was suggested by my learned friend a couple of moments ago. The exact sentence was, "You're an experienced witness, you're doing your best to dress it up." I'm assuming that was an unfortunate casual, I don't know what it was, I don't think it should have been said, but if there's any suggestion that Dr. Hickey is doing anything other than providing his objective professional opinion, and I want to know now, please.
Well, I think he summed it up at the end by saying his job was to provide the value of the change as he saw it. And it's up to others to draw the conclusions. But it was the earlier comment.
It's the inference that Dr. Hickey, this was the exact phrase, was doing his best to dress it up. I assume that was just a passing comment, and it's not being. All I want to ascertain is that it is not being suggested that.
You're not saying he's been unreasonable in the approach these days.
I'm not saying it's been unreasonable, no, sir. Exactly.
No, where we've got to in a lot of those discussions is a difference in assessment of value between Mr. Smith and Dr. Hickey. Is that fair?
I think that is distinction. Yes. as well as differences in approach in the way that we've discussed.
Yes, there's some methodology issues that you've opened up and dealt with. Appreciate that.
We're slightly ahead of our time slot now, aren't we? Already?
Yeah, a little bit, but let's not
Last words. I'll eat those words probably this time tomorrow.
Yes, we are a little. Dr. Hickey, for purposes of your evidence on landscape matters, you may stand down. We're going to see you again.
Thank you, sir.
You may stand down. I think that there's nothing to be gained by trying to move into a further evidence in chief now. I think it's better that we reconvene at 9:30 and pick it up at that point. Is that agreed?
Yes, sir, absolutely. I think we.
Thank you very much.
Just looking at the timetable. I suspect we ought to be prepared. It may be that we don't get this far, but we all ought to be prepared to deal with Mr. Dawes, at least Mr. Dawes. I'll certainly be prepared to call Mr. Burton if we have to.
I appreciate that, but I will take Ms. Sargent's lead to a certain extent on that, because it was not something that she would have.
That's fair. That's
in the run into this inquiry, but we've reached a point where it is. But let's just say we head into tomorrow with Mr. Smith. In terms of timing, it certainly seems that we'll be very comfortable to complete that in the period of tomorrow. So, but equally, I don't want to create any element of unfairness by pushing aside. But Ms. Sargent, I'll be led by you on that.
Mr. Banner, I think I do have quite a long cross-examination for Mr. Smith in the light of today's evidence, but I think we will absolutely get him on and off tomorrow. As I've said, I don't think I don't know how long Mr. Banner wants for Mr. Dawes, not that long. So Mr. Dawes won't take very long.
It's a fairly discreet point. If you're happy to take the in chief tomorrow.
I'm happy if we have time, which we might well, to deal with Mr. Burton as well. The only point I would like to clarify with you, sir, if possible, is because I do have to think about Mr. Dawes' evidence this evening, I would like to know, as far as we are, whether there's any prospect of us getting onto the heritage evidence in chief, because I was going to turn my attention to that this evening, but I've now
not tomorrow. I think it's entirely fair to say not tomorrow.
Thank you. I'm very grateful for that clarification.
So can I just ask of you, in terms of Mr. Burton's chief, and I've got to sort of reflect in terms of how much evidence in chief I need to do in light of the what's been said this morning about Mr. Dawes, but can I take it that the evidence is read, because there's quite a lot of nuance and detail in that. There's no point sort of holding his hand and talking you through his evidence if you're familiar with it and familiar with the various appendices, etc. I'll just take it as I may take it as and ask him to read out his summary and leave it at that. I can't promise, but I may do it.
It is read. Don't forget that we are, despite the fact that we don't have many in that audience, we might have many more in that audience.
Yes. So I might get.
Therefore, there needs to be a scene at least for me, and the summary might just do that. But equally, you've got it now as a fairly defined point. Any overlap with Dr. Hickey's you can deal with, because and Mr. Dawes' 4A is a fairly defined point that you can.
Indeed, and there's no point in me doing a sort of page turn for the sake of adherence. In a sense, if it has been read and will be read in due course, then I don't want to kind of
No, but equally, I have to be conscious that
indeed,
we aren't necessarily. We're not absent people who want to engage with the inquiry and understand the points that are being made.
But we'll bear that in mind. Callum is chief.
Good. Thank you very much. I think that's helpful. Just to confirm that we'll meet tomorrow at 9:30 for Mr. Smith.
Yes.
We'll see how well we get on with Mr. Smith, but I think there's a fair chance that we'll get on to Mr. Dawes tomorrow. I'll undertake that if we go incredibly well, or quickly is perhaps another way to put that, that even if we achieve Mr. Burton's evidence tomorrow, in time, we won't go into Dr. Hickey's heritage position.
Thank you, sir. The other point is, the live stream is required for the council chamber from 5 o'clock tomorrow, so we can't run past 5 if we want the people on the live stream to be able to be with us still in any event.
That's very helpful to know. So, yeah, thank you for that. Very good. Thanks everyone for your time today. Look forward to seeing you tomorrow at 9:30 for day 2. Thank you very much.